Take the email dated 4th of January 2025. Full stop. After checking the mail, petitioner could not find any mail in his account on 4th of January 2025. Accordingly, he rushed to the office of the HPCA. On 9th.
I'm getting old. I'm sure. I am forget to place my page. On second, they asked me to produce these two new factors. That document is very factually not be.
You said that it was placed on 9th.
7th was ready placed. For rest 2, booking slip was given, RC was given. They asked me to produce on 2nd. That you also can get page 56. At the bottom, date is given. Differently placed. 7th placed, examined, agreement entered into, started loading.
And you are saying rest?
Rest 2, 56, asked me to produce on 2nd. We produce on 2nd the trucks, new trucks. With RC book, everything, only the smart card was available.
You placed the 2 trucks on 2nd?
They asked me to produce on 2nd. You also can get the at the bottom the date. I'm sorry,
but not the all documents.
Only everything was produced. I have shown you not the inspection slip also. Only smart card was available.
But if your lordship once comes to page 65, which my learned senior friend is indicating as a RC book, my lord, but this is the application receipt. If your lordship comes to the bottom of this particular document, with a note it shows this is a computer generated document, authority signature is not required. The document can't be used as MV document in the vehicle. That means it cannot be treated as a motor vehicle's document.
That is smart card. This much I have.
Okay. Bolo, bolo. On 9th of January 2025, on the same day, he received the copy of provisional letter of acceptance. It is the further submission of Mr. Basu that on 2nd of April 2025, the new TTs were placed along with all documents except the smart card. Full stop. However, fact shows that the concerned authority, after inspection, found that the required document of 2 new TTs were not placed according to the terms of the agreement. Thus, they have cancelled the LOA issued in favor of the petitioner and terminated the contract by an order dated 10th of April 2025. Hence, this writ, learned counsel Mr. Basu submits that the act and action of the concerned authority is illegal in the eye of law, though they have produced the documents within the stipulated period of 90 days, which would be reckoned from the date of 9th of January 2025. But the order itself stated the last date, the stipulated 90 days is ended on 4th of April 2025. The observation of the concerned authority regarding the end date for submission of the documents of the new TTs is erroneous. He further submits that The the issue involved in the instant writ petition arose before this court in a writ petition being number WPA. In a writ petition, in a writ petition in WPA 23542 of 2024, wherein this court has observed that for irregular reporting of some TTs, the entire agreement of all the TTs between the petitioner and the HPCF and the oil company cannot be terminated. The observation of this court has been upheld by the Honorable Division Bench in MAT 1905 of 2024. He placed the relevant paragraph number 15 of the observation of Honorable Division Bench, which reads as follows. Paragraph 15 paragraph 15 set of full stop. Mr. Basu submits that the 7 TT, the letter of acceptance was issued in respect of 9 TTs. All 7 TTs are running in good condition. The 7 TTs are running in good condition according to the terms of the agreement. Thus, the entire letter of acceptance and the agreement issued in favor of the petitioner cannot be terminated. He paid for an interim order. Full stop. Mr. Chatterjee, learned counsel, appearing on behalf of the HPCL, submits that provisional letter of acceptance has embodied certain conditions to be complied with by the tenderer. Full stop. Including those conditions, condition number 3, 4, condition number 3, 4, and 5 are relevant to set out, relevant to be mentioned here, or relevant to set out herein. Full stop. বলে 23, page 23, শুধু এইটা করবে, Mr. Chatterjee further argued that in terms of the said agreement, the petitioner required to produce the original RC books, calibration certificate, explosive license, and fitness certificate within 90 days from the date of issuance of LOA. Mr. Chatterjee formally submits that the LOA was issued on 4th of January 2025. Within that period, the petitioner could not place those documents. He further submits that the petitioner applied for the explosive license before the authority only on 7th of in respect of 2 TTs only on 7th of April 2025 and 9th of April 2025. The last date for submission of the documents was ended on 4th of January 2025. Thus, the impugned order passed by the concerned authority is justified. He further submits that in terms of the condition of LOI, and in terms of the agreement between the parties, if any tenderer failed to comply with any of the formalities as specified in the LOI, including the specified time, the entire LOI can be cancelled. Full stop. The concerned authority has acted in terms of the agreement. So the action of the authority cannot be called into question. He further submits that the the authority issuing the tender is the best person to interpret the tender. So to interpret the tender, so at this juncture, no interim order can be passed. Mr. Chatterjee submits that the act and action of the authority may be justified by placing the affidavit in opposition in detail. Having heard the learned counsel for the parties, also considering the materials, it appears that the petitioner, being the tenderer, has placed all the 9 trucks at the time of inspection. Okay. Clause 3 of the letter of acceptance imposes condition to produce all the documents of the TTs at the time of verification, that is RC book, calibration certificate, exclusive license, and fitness certificate. Admittedly, the petitioner placed 2 booking slips for purchasing for placing 2 new TTs. Full stop. It is the case of the petitioner that they have placed all the documents within 90 days from the date of receipt of the LOA, which was contradicted by the concerned oil company. However, it appears from the pleadings that petitioner has pleaded the fact of receiving, fact of date of receiving of the LOA, that is on 9th of January 2025. The matter requires to be considered on affidavits. Full stop. In considering the prayer for interim protection, it appears to me that the law has been settled by the Honorable Division Bench in MAT 1905 of 2024 that the oil company cannot terminate the entire contract, though some of the TTs were not placed properly. I further peruse that according to the clause 4 of the LOA, the all TTs has to be placed. The physical 9 TTs were placed on the date of inspection. Only documents were not placed. Full stop. I find nothing to hold that the petitioner has caused any deliberate delay in placing those documents. It appears from the application of registration of those TTs that the application for registration was placed. Date of registration was mentioned there, that is on 25th of March 2025, which is much prior to the date of much prior to the last date of submission of the documents. Considering the entire circumstances, I find that substance in the prayer of the petitioner, full stop. Prima facie, the petitioner has placed the sufficient materials to hold that the act and action of the concerned authority in passing the impugn order dated 10th of April 2025 is prima facie arbitrary. Furthermore, it appears to me that whether the petitioner has placed the documents within the 90 days from the date of receipt of the LOA would be considered at the time of filing hearing of this matter. Full stop. Till then, the impugn order passed by the concerned authority be hereby stayed for a period of 8 weeks from date. The respondent authority shall allow the petitioner to carry with the contract with rest 7 terms. Carry with the agreement with rest 7 terms. The respondent authority has leave to file the affidavit in opposition within 3 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list. Party elevated matters.
But may it be 4 weeks instead of 3 weeks, my lord?
4 weeks. Affidavit in opposition within 4 weeks.
Your lordship, pleasure to take up the item 21 now, my lord.
Peter.
My 21 will not take more than 1 minute.
My lord, item number.
My lord,
18
item
and
number 21,
Both
my lord,
parties
both parties, I am for the contempt applicant.
are-
And my lord, my other side is there. My lord, what happens, my lord, already they have mentioned the matter and today the matter is in the division
We
bench.
have prefer an appeal against your lordship.
I know.
And
This is the contempt matter.
My lord, appeal has been listed before the honorable division bench.
today it has been listed. So, my lord, let this matter be fixed on, my lord, the 14th May as to be mentioned.
27 serial number in the division.
Okay.
My lord, let this matter be taken up as 14th May as to be mentioned. Top
I have no objection.
Item number 21.
21, my lord.
Let the matter appear in the list. No. According to the submission of the learned counsel for the parties, honorable division bench is on session over the appeal arising against the order passed by this court. Full stop. Let the matter appear in the list on 14th of May. 14th of May under the same heading.
My lord, that to be mentioned, my lord. As to be
Under
mentioned.
the same heading.
Same meeting. It is under 2 minutes.
All the Passover matters.
My lord, after Passover, if your lordship kindly allows me to place 18 and 19. Before I enter, my lord, your lordship called the matter number 20. And other side is here, my lord.
18, 19 is Passover.
Passover.
Yes.
That
All are Passover matter. Just
Yeah.
wait. Okay. Call Passover matter. Item number 12.
Item 12, your lordship, I am for the petitioner. State is represented, your lordship. I have served your lordship to the private respondent also, your lordship.
Yes, what is the matter?
Yes, your lordship, very short matter. Your lordship, this is connection with a tender of fair price shop. Now, your lordship, the tender floated by your lordship, the state of West Bengal, Murshidabad division. Now, I applied your lordship and participated in the tender. As per the tender, your lordship, I have to show that I own or my family members own a particular land and a godown for the purpose of your lordship running the fair price shop. I duly, your lordship, given all the documents. Thereafter, your lordship, they make an inquiry also. They called for me a personal interview. But thereafter, your lordship, I have come to know that this particular my application has been rejected. Why? Reasons, nothing mentioned. From the phone, I have downloaded, your lordship, that my application has
The
been rejected.
portal says that
Portal
your
says it has been rejected. Why?
rejected.
What purpose? I don't know. Now, subsequently, I've come to know that the respondent number 4, who is a private respondent here, who did not actually own the land at that particular point of time when the tender was floated, and the persons who participated in the bid, that particular person, your lordship, has been declared as a successful tenderer, and your lordship, the state of West Bengal has awarded, your lordship, or rather, your lordship, given, your lordship, that tender in favor of the respondent number 4. May your lordship show, your lordship, the relevant terms of, your lordship, the tender, page 25.
Yes,
Page 25, your lordship, is the tender document. Now, your lordship kindly sees page 26, there is an eligibility criteria.
yes,
Clause number 8. Now, clause number 8, your lordship, the requirement, first, your lordship, the applicant shall, an individual permanently residing at Lalbagh subdivision, registered partnership firm, or in individual. What is important, your lordship, is at page 27. That is clause number 10, part 4. The applicant must submit the following copies or original supporting documents along with the application in form A1. In that particular, your lordship kindly sees clause number 7, documents related to godown and shop, documents regarding possessional right over the proposed place of business. So therefore, at the time of the bid, your lordship, I have to first show that I am in possession of a particular plot of land or godown.
yes,
Moreover, there are two types of, your lordship. I can actually, your lordship, possess the property, or my family members can also possess the property. Your lordship kindly sees 7A. In case of ownership, shared ownership, photocopy of the record of rights, porcha. So therefore, I have to show the porcha that this particular land or godown is recorded in my name. Thereafter, document showing character of land as Dokan commercial Vastu if the record of right is not produced.
yes,
Now, B, in case of property owned by a family members of the applicant, photocopy of the record of rights or registered deed of conveyance. In my case, your lordship, my mother, your lordship, possessed that particular plot of land or the godown. Your lordship kindly sees, before your lordship showing the other documents, may I also show clause page number 28, clause number 11, other terms and conditions.
yes,
Lordship, kindly take clause number Roman 4. When an application can be rejected, any suppression of facts or information or incorporation providing of wrong information in the application form or attached documents will be considered as a good and justifiable reasons for disqualification of a candidate or rejection of an application and taking appropriate legal action. So therefore, if I, your lordship, give a misstatement or your lordship wrong information to the state, then in that case, they can reject my application or or therefore, even if the application is allowed, they can terminate my awarded contract. Now, lordship, page 29 onwards, your lordship will see that I have given all the required documents. Page 29, your lordship kindly sees. Lokhi Poddar is my mother. Page 29, your lordship, is the Gram Panchayat document. Page 30, your lordship, is the record of rights.
yes,
Record of rights, my mother name was there. Thereafter, your lordship, whatever the required documents were there, I have duly submitted regarding all the eligibility documents. Now, they came for an inquiry, your lordship, kindly take page 58. Even the registered deed of conveyance, those particular documents, admittedly, I have given. Now, page 58, your lordship, kindly sees.
yes,
Page 58, your lordship later written to me, name Nilesh Poddar, who is the petitioner. This is to inform you that an inquiry into your application against FPS vacancy at central location such and such at your proposed shop come go down site. Therefore, you are requested to remain present at the above mentioned venue at the said schedule
with the original copies of all required corroborative documents as per the provisions of the West Bengal, Your Lordship, the Maintenance and Order, 2013. Now, after this inquiry, Your Lordship, they have called me for a personal interview. That is at page 59.
Yes.
Page 59, Your Lordship, kindly sees the letter dated 24th of January 2025, issued by the District Controller Food and Supplies Murshidabad to Nilesh Poddar. In reference to the above, you are hereby called for personal interview in respect of the application for grant of license against FPS vacancy such and such at the office chamber of your additional district magistrate on 28th of January 2024. I duly appeared before the personal interview, and thereafter, Your Lordship, no communication. Page 60, I found, Your Lordship, that kindly sees the right hand side, extreme right,
Rejected.
rejected. Now what they have done, they have given it to the respondent number 4. Your Lordship, I have made my searches and I have come to know, I have given a specific, Your Lordship, allegation, paragraph 17 of my application.
Paragraph.
Para 17 at page 9. That the respondent number 4, who has been awarded with this particular, Your Lordship, tender, had no, Your Lordship, property either possessed or in the name of his family members on that particular date. Subsequently, Your Lordship, the gift deed has been executed in his favor on 27th of August 2024, after, Your Lordship, the participation in the bid. And how this particular, Your Lordship, this particular tender has been given to the respondent number 4. There are two, Your Lordship, contention in my writ petition. Was first, that why my application has been rejected, because I have shown, Your Lordship, from the clauses in the tender that unless and until you say any communication that I have given a wrong information or misstatement, then in that case, Your Lordship, the tender cannot be cancelled like this way. Because you have to at least inform me that this is the misstatement, this is the fraudulent statement I have given. Simply, Your Lordship, from the app, Your Lordship, I have seen, Your Lordship, my application has been rejected and has given to such a person who is in himself, herself, Your Lordship, ineligible to participate in the bid.
So it is only your pleading, no
This-
documents?
This is my pleadings, Your Lordship. They have to justify. First, Your Lordship,
No.
why I
Today, do you have any document to justify?
I don't have any documents, Your Lordship. This is my, Your Lordship, information or knowledge, Your Lordship, I have gathered. My contentions are twofold in the writ petition. First, why I have rejected my application. The rejection has to be on a particular ground as mentioned in your tender document. You have rejected it, and then after you have given it to a third party without any even given me a communication, without any show cause, without giving any right to right of audience. You have simply rejected it, and the tender document says that on a specific ground only my application can be rejected. When I have given the entirety, you make an inquiry, you have called for a personal interview.
Have you filed any
Lordship, with deepest respect, your Lordship, is this the duty of the state to Lordship to give or the allot the tenders in a Lordship fair manner? When 24th of January 2025, you have given me a personal hearing. On 28th of January 2025, with all the documents, have you said so that there is an anomaly on the documents? Where I have given all the documents which were required. You are showing that one particular Khotian number is not matching with my affidavit. Have you seen the other particular requirements are all matching? Have you said so to me? Have you given me the chance to rectify it? Have you said so? This is a misstatement and fraudulent statement. Your tender document says so. And you have given it to the respondent number 4. Nothing said that the respondent number 4 was qualified, and that's why I have given to them. When I have made an application, at least an allegation, they should have come with the documents that show he's the eligible criteria. Respondent number 4 in Murshidabad. You are
No,
the
58.
page
58 is the document
yes.
for inquiry.
Inquiry.
Okay.
Yes, your
So
Lordship.
inquiry, when you file the application according to the control order and the rules,
Lordship.
you have to file an application. There may be some wrong there in application.
Lordship.
They should not bother about it. The SCFS shall send a person to inquire your proposed outcome go down.
Lordship.
They should take the note of all your documents,
Lordship.
they are required to take all the documents, the measurement of your proposed outcome, the location of your, and they shall indicate in the report what is the deficiency
I'm grateful.
or what is the sufficiency of your subject, whether you are eligible or not.
Lordship.
All the documents are placed before the district level fair price of selection committee. Thereafter, they will call you.
Lordship.
That's why they have called you for personal interview.
So they-
That is at 59.
page 59.
59. So district level fair price of selection committee shall evaluate you on 25 marks.
Gotcha.
Okay. Thereafter, the concerned authority, after taking all the reports, either allow you or reject you.
Gotcha.
This is the authority, and their letters, that is the page 58 and page 59, doesn't allow you to any justification or allowing you. Everything is there. Not there are no decision making process like that.
I understand, your Lordship, but after page 59, when you are dismissing my application, your Lordship, there has to be some grounds because tender document says so. Your Lordship, kindly sees the tender clause.
Okay. Okay.
Page 28.
Okay.
Page 28, your Lordship, clause number 4 is specifically mentioned that you can't reject like this. Any suppression of facts or information or incorporation providing of wrong information in the application form or attached document will be considered as a good and justifiable reasons for disqualification for a candidate or rejection of an application and taking appropriate legal action. When I'm saying, your Lordship, that I am the only eligible criteria and the respondent number 4 is not, and specifically given, your Lordship, the state has to show the honorable court that
Very
no, he is eligible
Okay,
and
okay,
I'm not eligible.
Very well. Petitioner applied for license in terms of notification dated 16th May 2024 issued by the SCFS Lalbagh. His proposed outcome go down was inspected by the concerned authority on 26th October 2024.
May Lordships kindly.
Thereafter, petitioner was called on for a personal interview on 28th of January 2025. Thereafter, it came to knowledge to the petitioner that private respondent number 4 was allowed to run the business and issuance of a license, and the candidature of the petitioner was cancelled or was rejected. The intimation for rejection was only appearing in the portal. It is the contents of the learned counsel for the petitioner that no reason was assigned by the concerned authority regarding rejection of the candidature of the petitioner. He submits that the terms and conditions of the vacancy notification, specifically the clause number 11 within bracket 4, depicted that if any wrong information was given in the application, or any fact was suppressed, the candidature may be cancelled. He submits that nothing has been brought to the knowledge of the petitioner regarding suppression of any fact by him or any false or any wrong information. So at this juncture, the act and action of the authority required to be stalled. Mr. Suman Sengupta, learned AGP, appearing on behalf of the respondent, authority submits that respondent number 4, being the most suitable candidate, has given the license of the concerned FPS. Full stop. The detagging has been done. Detagging has been done. Moreover, the respondent number 4 is distributing the recent articles to the PDS. So at this juncture, the no interim order can be asked. He further submits that the petitioner has placed an affidavit along with the application wherein he has mentioned the Khotian number of his proposed shop come go down, Khotian number of a land wherein the proposed shop come go down was constructed to be Khotian number 1855, wherein the LR record shows the Khotian number of Lakshmi Poddar, within bracket mother of the petitioner, is Lakshmi Poddar, within bracket mother of the petitioner, bracket close, is 9879. Mr. Sengupta further submits that there are other reasons to other grounds to cancel the candidature of the petitioner. He seeks for filing affidavit. Having heard the learned counsel for the parties, at present it appears that the respondent number 4 has given license who is running the business. Thus, at this juncture, interim order cannot be possible in this case. However, the respondent authority has given a liberty to file affidavit in opposition against the writ petition. Such affidavit would be filed within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Let the matter go out of the list, particularly what we mentioned.
Obliged to Lordship.
Next,
My lord, I am for the petitioner, my lord. The petitioner is a widow daughter-in-law of a diseased MR dealer. Prior to the death of MR dealer, his son, the husband of only son of the MR dealer and husband of the petitioner, has died. So during his lifetime, the MR dealer, who is father-in-law of the petitioner, has applied for transfer of the license to his grandson, elder grandson. But then the elder grandson, age of the elder grandson is not 18. So his application was cancelled. Then the petitioner, for the petitioner, his father-in-law written a application which was not submitted because he was seriously ill, fallen ill, and died. So after his death, within 1 month, his daughter-in-law applied. And after application, her application was forwarded to.
daughter-in-law means the petitioner.
Yes. No. Petitioner is the daughter-in-law.
So daughter-in-law applied.
Daughter-in-law applied.
Petitioner applied within 1 month of the death of the MR dealer.
Yes. Yes.
Then what happened?
And then it was forwarded, inquired and forwarded to DDPS. But it was not happen anything. Then DDPS once again requested the district controller to send his file once again. It was sent by the district controller to DDPS, but it was not happen anything. Then, my lord, the petitioner has, in the meantime, they have notified the vacancy. Then challenging the vacancy, the petitioner has approached before your lordship. Your lordship has directed the government, the state respondent, to dispose of her application. Her application was disposed of and cancelled, saying that she has 5 sister-in-law who were married, and as per the cancellation order, two sister-in-law have not given NOC, and as the applicant is daughter-in-law, at that point of time, daughter-in-law is not included in the definition of family, but after 6 months it was included. So right now, my lord, my submission is that this division bench of this honorable court has clearly stated that no objection certificate is required only from those who were dependent of the deceased MR dealer at the time of death. But none of the daughter of the MR dealer were dependent on the MR dealer. The MR dealer, the applicant, along with his 2 minor sons, is only the dependent of the MR dealer. And second contention is, my lord, that she is that daughter-in-law of that when it was applied and he was died, but one coordinate bench of this honorable court has clearly stated, given one where the MR dealer was mother-in-law, or no, that grandmother-in-law. In that case, the grandson was allowed to transfer the license. And my lord, the Supreme Court has clearly said that the application should be considered on the day of consideration which norms is applicable. So it was not that when the MR dealer was dead or when the petitioner has applied. When the respondent have considered her application on that day, which norms was applicable, that has to be considered. And in that case, she is clearly eligible, my lord.
What is your prayer now here?
Now my prayer is, my lord, please direct the state respondent to engage the petitioner on compassionate ground. My lord, in that case, my lord, please direct the state respondent not to proceed with the vacancy notification.
What is the order?
162.
Page.
Yes, my lord. Your order, my lord.
Impugn order.
Impugn order 162.
P16 order dated 28 January 2025.
Okay, got it.
My lord, point 2, application received, Srimati Chintamani Sarkar.
Who is Jawawala Sarkar?
one of the daughters, my lord, who has also applied it.
Who also apply?
But his application was also cancelled because she neither,
Both the applications were cancelled.
yes, she neither have any go down nor submitted any NOC.
She is a dependent. How can my learned friend say she is not a dependent?
She is not a dependent. At the time of death, she was married. Still, she was married.
Married daughters does not mean married daughters are not dependent.
No, the married daughter is not dependent. I can show you the judgment also.
I can also come back to you. Very recent.
And my lord, they have only 700 cards. So in a month, maximum income is not more than 10,000. And literally they have nothing.
Now they have no cards like that.
No, the cards were officially tagged. But as their condition is very poor, so on request of the local panchayat and people, the villagers, the nearby dealer with whom the card tag allowed her to continue.
That is the internal arrangement.
No, what is the now what you want in this case? Let them file the affidavits.
Okay, no issue. But my lord, with a interim order that in
What
between,
interim order?
in between, they will not proceed with the vacancy notification.
No, they have to proceed.
No.
Your lordship is these matters. There is always a public element. Your lordship knows. Essentially, these are distribution of food grains.
Yes.
Already distributed.
Private, your lordship today stops us from proceeding with the vacancy notification. That will, disturb the entire scenario.
My lord, they can.
Anything happens if your lordship thinks, we have wrongly given to appointed sub-person, it can be undone always,
My lord, as in your earlier order, you have directed that they can proceed with the vacancy notification, but they could not appoint anybody.
That time,
That is the 13 control order.
that is, at that time when your lordship has stopped us, a representation was pending.
Yes.
Today, nothing is pending, my lord. So
Okay.
we'll come back, Already give us 3-4 weeks of time,
My lord, kindly give us a protection, my lord. Interim order. I have no doubt. I can show you the judgments also.
Where is the of Honorable Division Bench. No, no, card holder with new FPS dealer has been stalled by the Honorable Division Bench, who has been appointed in pursuance to the vacancy notification declared under WBPDS Maintenance and Control Order 2013. Full stop. However, the challenge of control order is not placed in this writ petition, though it appears to me that if the authority concerned select any new person for the said vacancy notification, the third party interest may be created. At this juncture, I find it would be it justified to hold that to pass an order that the concerned authority may proceed with the selection process, but so far as the grant of license is concerned, the same shall not be issued in favor of any person without the leave of this court. Full stop. Let the matter go out of the list, particularly recognized.
Great, Your Honor.
Next. What happened? Nature matter. 18 should again.
Now I am appealing for the petition.
Yes.
I am filing my affidavit for this.
Sir,
Yes, my lord, other side is here, my lord. My lord, I am holding, your lordship kindly come to paragraph. Paragraph 3.
yes.
Where the petitioner is running the dealership by distributing commodities amongst about 5,300 ration cards. The lordship will kindly mark, my lord, only 5,300 ration cards are there.
Yes.
And there are 8 villages. PPR, their names have been written. Now, my lord, the vacancy has been created. Your lordship kindly come to page 19.
2024.
Your lordship got, my lord. Page 19, location.
Yes.
That is Jagdishpur, Jama Masjid and service area. Kindly see service area, Chandpur, Jagdishpur, Paschim Pipla. And I am already catering only 5,300 ration cards, which includes Pipla, Jagdishpur, Chandpur. In paragraph 3, I have stated, my lord. So, my lord, the impugned vacancy is bad because your lordship knows, my lord, that 5,000 ration cards I may retain.
Let them take a report, short report.
And moreover, your lordship just sees page number 19, P2,
Vacancy notice.
2/1/2025.
Yes.
Controller order, maintenance and
24.
control order 20.
I am not
No,
saying
that is not the issue.
that is not-
Issue is that you take a report whether his ration card is going to be taken by the said vacancy. or not.
Detag,
You have to be dealing done.
delinked or
You
not.
take a short report. Next week, you take a short report and come with the report.
But lordship, may I humbly submit, this is a policy decision of the government.
I understand. I understand.
But
So-
I am relying upon their policy.
Yes, very good.
You see, since I am relying upon their policy,
But
under
you-
their
but-
policy, I cannot have less than 5,000 cards. So they cannot deduct my card, my lord. So what the interview?
Lordship, may I just file the report first in the first place? If lordship desires, then we will take it to the, make it in the form of affidavit. The report I'm just desiring from
File
the
a short
government.
report. You file a short report regarding the status of the new vacancy, how the vacancy was created, and which ration card is required to be tagged with the vacancy. Okay.
My lord, in the meantime, your lordship will write.
No, 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 no.
No,
No,
they
your
will come
lordship.
within 7 days.
And
Within
moreover,
7 days, my lord.
Within 7 days, they will price the short report.
moreover, in many judgments that have been passed by lordship has always said that if erroneous decisions have been taken by the state, they can always be rectified. Lordship has
Yes.
ample
that can-
powers. And lordship,
can
I do not need to
But now the
apprise
third
your
party
lordship.
right is created.
No. But let
So,
let
my
us
lord,
come with the report. It's a very short date.
7 days, I want short report.
My
Okay.
lord, Monday next.
I am passing.
Today,
Monday, lordship has kept many matters. Let it be Tuesday or a Wednesday.
Okay. Having heard the learned counsel for the parties, it appears that before passing any interim order, a short report from the state authority is required to be placed. Let the short report be placed on 30th April, Wednesday. 30th
my
April.
lord,
30th April,
30th.
Wednesday.
20th.
Under the same heading,
Right, my lord.
what do you want, Mr. Agarwal?
My lord, it's your 29th, whatever you
Bolun
lord.
na.
No, I have also placed some
I'm
matter.
having some difficulty.
No, I have not.
Okay. Already Monday,
The only
Tuesday,
one
I have picked several matters. So
Yes,
that is the issue.
I can't
Nothing
say that.
that.
I reasonably believe that my learned friend will not.
Yes, they regularly place the reports. They regularly place the report with this court.
Now he's asking us such questions which is making us very embarrassing to us.
No, not necessary. You know? Let the matter appear in the list on the date.
And then
30th.
same position.
Affidavit of service file number will be taken now. Next,
Well, this matter I am appearing for the petition, my lord. My lord, kindly come to paragraph 8.
I appear for the
No, my lord, sorry, my lord. Paragraph 4, my lord. Paragraph 4 of the petition, my lord. Quickly, I am taking a look, my lord. That petitioner had a land. This is pursuant to vacancy notice. I was the applicant. Now, kindly come to paragraph 4. The petitioner had a land measuring about 13.1/4 decimal at tag number 470.
yes,
Page 3, paragraph 4, bottom.
yes,
470, I have got the land which was classified jal in the records of right, and this is the petition applied for conversion, which was allowed and classified as vastu. That is at page 20, my lord, will kindly see. 20 is the, my lord, copy of record of right. Is that at page 26.
yes,
Proceed 470 tag number. My lord,
yes,
470 and vastu.
yes.
Then, my lord, after conversion of the land, I constructed a godown and I made an application. Now, my lord, to enter for ingress and egress, I had to make a culvert on plot number 469. That your lordship, my lord, 469, a portion of the 469 is also gifted to me. That will appear from, my lord, page 5. That is, my lord, page. There was a culvert and I developed it so that ingress and egress may be smooth. 469, my lord, that is Ganpatra at page 31. Relevant, my lord, at page 35. Page 35, my lord.
Yes,
RS to LR tag number 469. Tage record moto 5 ভূমি মোট 12 ডেসিমাল মধ্যে আমার নিজের নামিতে এক মাত্র ALR Katiyan Mutto 0.333. So I have got the land on 469 also. There was a culvert, temporary culvert. I made it a permanent culvert. And from that I am going for ingress and egress. Now a complaint has been filed by the co-owner of 469.
yes.
That I have encroached his portion. That is not here and there. Then, my lord, on that complaint, my appointment has been rejected. Only on that complaint. Inspection of PLR was done. Your Lordship kindly come to page 44, last page.
No,
Last but one.
admittedly, the 469 is the co-sharer plot.
No, I have got 0.333 and other portion is of the
Other
other
person.
person. He says that my land has been in court, his land has been in court for indecent.
So you have to submit the no objection of that person.
Oh, why I shall do this is on my land I have done. It is remarketed land. My lord, kindly come to page.
Marketed by partition by Midson.
No, that's the reason that his application has been rejected. He has pleaded my case as well.
My lord,
So now what you want?
I want that.
Only affidavits can be filed.
My lord, will kindly come to page 35 once again. Page 35, that 469. That is marketed. There is a
No, তারপরেতে RSS এর 469 469 দাগে রেকর্ড মতে মাতভূমি মোট 12 ডেসিমেলের মধ্যে আমার নিজ নামে তো অত্র এলে খতিয়ানভুক্ত
Only 4 decimals.
yes
no, my lord, kindly.
so the other court has disputed
Your lordship,
So
that
that's
is the
why-
boundary. That is boundary has been mentioned. 470 দাগ তোমার নিজের দখলীয় ভূমি উপরি
ঠিক
that is my দক্ষিণ জল নিকাশি নালা পূর্ব গ্রাম জেলা জল নিকাশি খাল পশ্চিম অত্র 469 দাগের অবশিষ্ট অংশ বাদ
Mr. Agarwal, no, you know that the matter is regarding land disputes
yes
and the authority cannot dispute.
one thing I just told you. Page 44 kindly come.
Yes,
An inquiry was held by the block land and land reforms officer
for what?
regarding this complaint, regarding this dispute. Page 44.
So what is the observation of the BLR?
No report. Let my learned friend file a report from the PLR of what he has seen.
Is the BLR party in this matter?
Yes,
general party
PLR has filed a report to the state. The state should produce that report. Let them come with a report. On Monday, let them come with a short instruction.
let the BLR be made a party
PLR has already submitted the report.
Now, whether BLR submitted, why BLR started the inquiry?
Under as per their direction, can you see the complaint? There is a complaint.
As per direction of the BDO.
Yes. There was a complaint for the video. Video has
well initially the prisoner was found eligible but for the complaint by a co-sharer of a particular plot of land 469 well his application has been
You
rejected
submit a representation before the authority.
I said, man.
You
That's it.
submit a representation, let them consider the representation along with all documents.
yes that can
That would be better.
My lord. Yes.
Okay.
To the
You submit the representation within 7 days.
go to principal secretary.
They were the
Principal
principal
secretary.
officer.
He's a approved building authority. He can. No one can
No.
approve it other than
principal
Now,
secretary has other
whether,
business.
what is the status of the FPS? Whether it was granted?
Rejected. And
He's-
there is no other application.
No one has.
Other application.
Okay, okay, okay.
That's why,
So-
my lord, since it has been rejection has been approved by the secretary, he can only consider, mother.
well this is difficult well there are other authorities well if every matter goes to the principal secretary then
Not
principal,
every matter. This
the
matter
principal
since has been
secretary's job
approved,
will be
this rejection has been approved. Otherwise, I could not have a fancy for the principal secretary.
Now you go to the district collector, district controller.
District controller has no authority, my lord. Approving authority is the principal secretary.
Now who rejected? SCFS?
No, no, my lord. Rejection is done by the with the approval of the principal secretary.
Principal secretary not the party here.
No, yes, my lord.
Principal
State
secretary is not
always
a party.
State is always a party, my lord.
It is the party but not the principal secretary
Printed by the principal secretary,
no no
Then you go to the director.
as your lordship, my lord.
Go to the director.
Yes. Then I shall make representation for the director.
Yes, yes. Please take down. Petitioner applied for FPS license in terms of a vacancy notification number 350/MR TFS 23 dated 9th August 2023, declared by the subdivision controller, food and supply, Tamluk. Full stop. The petitioner offered plot number, LR plot number 470 for the purpose of proposed shop cum go down. His proposed shop cum go down was inspected by the concerned authority, and initially he appears to be the most suitable candidate. For the purpose of ingress and egress to the proposed shop cum go down, the petitioner used a plot number 470, which was recorded as Ban, as a road within bracket Ban. He has constructed the.
Well, I have not constructed that. There was a construction. I have just made, kindly come page 28.
There is a construction of what?
That culvert.
Okay, that is not the issue. Culvert is not.
Yes,
the issue.
culvert is the issue. That culvert is on 469. And that culvert has been made concrete. That was it.
Well, your lordship
You-
did not make
Yes.
mention the culvert. Your lordship
Okay.
about
No, no, that is page
plot number
28.
439.
Page 28 kindly
The
see.
culvert is there or not?
No, no, that is the
I don't know.
that is the complaint. That's a complaint.
28 is the
Page 20.
scale, hand sketch.
Yes, last week at the bottom, my lord, Jal Nikasi Khal, and there is Barampath. This Barampath has been
Yes, approach road.
yes. This Barampath
Varampak means approach.
469.
Yes, that is 469. That is the approach road is 469.
469. And that
One co-share has raised objection. That is the issue.
Post here. No, adjacent landowner.
One of the
Adjacent
one of the fourth
owner of
69 plot is
469.
not a partitioned one. It's not partitioned.
That is 470. 470 is the land.
470 is the godown. And
One of the
469
approach road is through
469.
469 is the disputed plot.
Yes. Where you have shown to be the approach road.
approach road that was already there, but I have made it concrete.
Okay.
That is my case.
Let him mention all these things in the representation.
Nah,
I have made it
469.
My submission to be recorded.
Now the 470. One. For the purpose of smooth egress and ingress of the ration articles, of the truck of ration articles, of the truck carrying ration articles, the petitioner has concreted the same road over plot number 469. One of the adjacent landowner has raised objection, raised complaint with the authority, by which the authority has cancelled the candidature of the petitioner. It is the submission of the petitioner that the person making complaint with the authority has no right to make the complaint, and the concerned authority, though has conducted an inquiry through block land and land reforms officer, Tamluk 2, did not submitted any report. However, the petitioner was unaware about the reason for rejection of his candidate. Hence this state. Mr. Dotto, learned counsel appearing on behalf of the state authority, submits that the concerned authority has considered the complaint of the person, and after considering the correctness of the complaint, rejected the candidature. It appears that the instant read petitioner has demonstrated the fact that he is the most suitable candidate for getting the license. However, his candidature was rejected by virtue of a complaint made by a person residing vicinity to the disputed plot of land. The issue for rejection of the candidature and justification thereof has to be dealt with by the authority. Again, considering the same, I direct the petitioner to approach the director, District Distribution, Procurement, Supply, Food and Supply Department, Government of West Bengal, being respondent number 2 of this writ petition, by filing a appropriate representation along with documents. Full stop. The
Document regarding disputed land.
within 2 weeks from the date
Within
of
1
passing.
week, my lord. I shall give within 3 days.
Okay,
Within
within
1
2 weeks or within 1 week from the date of passing of this order. On receiving the representation, the respondent number 2 shall dispose of the representation of the petitioner after giving a reasonable opportunity of being heard. Within 6 weeks there.
Within 2 weeks, my lord, 6 weeks, they will again declare the vacancy. In that case, my lord, your lordship kindly stay that they
আরে গভর্নমেন্ট ফাংশনটা করতে হবে তো
গভর্নমেন্ট কি বসে আছে এখানে
6 সপ্তাহ
No.
মানে গভর্নমেন্ট
It's a reasonable time.
Director have some other duties.
maybe my but
right?
6 weeks are
Okay, come on,
in the meantime there will be
come on, 4th week there.
there can be vacancy, my lord. They will declare
If their vacancy is there, I have passing the direction. They have to dispose of that. Otherwise, they cannot.
before that if they do that's why my
If they declared vacancy, you come to this. I'll pass the order.
Come again,
Issue.
come again. You will have another petition.
weeks,
Another-
3 weeks.
Another
Only 3 weeks, my lord.
No, 4 weeks. 4 weeks.
4 weeks thereafter, after the making of the representation.
After making of the representation. Within 4 weeks after making the representation. Within 4 weeks from the date of representation. Full stop. The decision of the authority shall be intimated to the petitioner within 2 weeks thereafter.
In 1 week, my lord, otherwise again that holiday will come, my lord.
কিসের holiday আছে?
Vacation আসবে না?
I make it clear that this court has not entered into the merit of this matter. The concerned authority is a leave to dispose of the representation according to the law without being influenced by any observation of this court. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been ordered.
That's a great.
Deeply, okay.
Fixed matter.
For the respondent.
Yes, which for the petitioner?
I am for the petitioner, madam.
Yes.
This is a matter for appointment of retail outlet dealership in the district of Bakura. I am filing affidavit of reply.
Hello.
Factual.
Yes. Now, what are you submitting?
My account number is 28. Coming from Vacancy.
You are coming from?
Delhi.
Okay.
Your honor, permit me. It will take hardly 1 minute for my submission. Please allow my lord. I have right. At
Just-
last,
No, this matter is fixed at 12:30 p.m. Now I can took this matter now. So your matter can be taken up at 2.
all right.
You just wait. I will take up your matter 2. Okay.
One advertisement was published by the respondent authorities for inviting names of the candidate for the dealership situated in the district of Bakura. In the advertisement, there is some criteria in respect and eligibility criteria is mentioned that
Yes.
those who have applied for the subject local, they have to offer a land under 3 category. There is a 3 classification of land. First of all, Malar, I am placing the facts synopsis of this case. Thereafter, I show the documents. 3 type of classification of land is mentioned in the advertisement. The private respondent offer a land category A,
Yes.
wherein in terms of the lease deed, there is a sort of frontage of this subject land which is offered by the private respondent and also depth of the land. In the advertisement, there is specifically mentioned that if the land is offered, then the frontage of the land should be 30 square meter and the depth should be 30 square meter. In the meantime, after participating in the selection process, letter of intent issued in favor of the private respondent by the respondent authorities. I annex the lease deeds, which is submitted by the private respondents. In the schedule of the lease deed, they have filed 2 lease deed. In the year 2018, 1 lease deed was executed. In respect of, they are mentioned, this lessor is 4 lessors. Now, in terms of the records of right 2018, there the owner of the land is 2. How 4 can be given lease to the other in the favor of private respondent? In the schedule, there is a shortage of frontage and depth, which is mentioned in the advertisement. Immediately by filing the writ petition, I am challenging the letter of issuance of letter of intent in favor of the private respondent. Now, kindly come to page 820 once.
Page
20. 20 notice for appointment of regular and rural retail outlet dealership. Hindustan Petroleum Corporation Limited proposes to appoint retail outlet dealers in the state of West Bengal as per the following details. Now kindly come to the heading portion, frontage and depth, column number 8. Kindly see. Column number 8, first column. Kindly see name of the location. Then
Yes, got it.
frontage and depth.
Minimum dimension.
Yes, and kindly see the subject local is mentioned in page number 23. This advertisement in respect of different plots of land and different schedule. Now kindly, we are concerning serial number 114.
Okay.
Which is within 2 kilometers for Jorhira High School, Saltora to Jhanti Pahari Road. And kindly see the measure depth and front 30 square meter. Now kindly see. In terms of the advertisement, petitioner also applied, private respondent also applied. And kindly look to my lord, the tenure of the dealership for 10 years. Page 33 is mentioned that the tenure of the dealership shall be an initial period of 10 years and renewable every 10 years thereafter. Page 33.
Yes.
Page 35 is the application filed by the page 35 is the application filed by the petitioners. Petitioners, Vishwanath Ruidas.
Yes.
Wherein the land also mentioned, kindly see page 36, why I am showing before your lordships, wherein the land, kindly see the depth and frontage 30 square feet is mentioned.
Yes.
Now kindly come to the brochure, page 38 of the writ petition. Wherefrom we can see the classification of land, page 42 relevant.
Yes.
Page 42, kindly see Roman 6 land. The application, the applicant should be classified into 3 groups as mentioned below, based on the land offered and land not offered by them in the application form. Group 1, the applicants having suitable piece of land in the advertisement location area either by way of ownership and long-term lease for a period of minimum 19 years, 11 months or as advertised by the OMC. Then group 2, the applicant having farm offer for a suitable piece of land for purchase or long-term lease for a period of minimum 19 years, 11 months or as advertised by the OMC. And group 3, the applicant who have not offered the land in the application, only applicable for location advertised under ST category. Now the private respondent and also the petitioner applied in the category number group 1.
Group 1.
Group 1, where the applicant long-term lease for a period of minimum 19 years, 11 months is mentioned.
Yes.
There is a, in the brochure, there is a procedure for evaluation of land offered by the participant. Page 65. I'm just showing before your lordship the relevant provisions. Page 65, there is a provision for land evaluation. The concerned divisional, regional, territorial office shall inform the provisionally selected candidate through email, SMS at least 10 days before the day of visit by LEC for site evaluation. There is a provision for site and also site evaluation that is called as land evaluation. In case no response, non-availability of the provisionally selected applicants, the candidature shall be cancelled under intimation to the provisionally selected candidate through SMS or email. Evaluation of the offered land will be carried out to ascertain land being in advertised and suitable development RO meeting norms. And there are certain parameters. Kindly see the land falls within the advertised area and land dimension meets requirement after leaving right of way in the line of the road, and land meets NHI norms and land has no HT line. My contention is that point number 2, land dimension meets requirement after leaving right of way line of the land. If the land evaluated correctly by the respondent authority, then by the land offered and the deed submitted by the private respondent in respect of the appointment of the dealership should be scrutinized, and wherein from this schedule I can show before your lordships that there is a shortfall of frontage and depth. How the letter of intent has been issued in favor of the private. That is the case of the petitioner. Now kindly see next page, page 66. Page 66, second paragraph. First paragraph. In case of offered land is found to be suitable, the LEC will submit recommendation to the divisional, regional, territorial head of carrying out FVC in the provisionally selected candidate. Now, in case the land is not found suitable, the provisionally selected candidate will be informed about his and her ineligibility and rejection of his and her candidature. In this case, my lord, that provision has never been exercised by the respondent authority. The selection process will be continued with the balance applicant, that is the including the petitioner and other applicants therein. Now there is a provision for field verification. If the field verification done in appropriate manner, then the lease deed is submitted by the private respondent is not at all eligible. Then kindly see point number 16, which have been issued. Letter of intent is issued in favor of the private respondents by the respondent authority according to them after scrutinizing all documents. Kindly see if the information given in the application by the applicant is found to be correct and no selection related complaint and court case is pending for decision, letter of intent will be issued to the provisionally selected candidate. I pause here a moment that the information given by the application by the applicant is found to be correct In this case, my lord, that is not done. If the lease deed, schedule of the lease deed is mentioned that there is a shortfall of requirement, frontage and depth, then the information given in the application form is false.
So your contention is that the lease deed which was placed by the private respondent
Yes.
is not minimum criteria. was
At
not
per
there.
the minimum eligibility criteria as
Where is the
mentioned,
lease deed?
kindly see. There is a provision page 67 also, 67 withdrawal of LOI.
Yes, that is not the issue. They show me the
Yes. Kindly
Yes.
see page 87. Page 87. This is the first lease deed.
so there are two lease deeds.
Yes. The private
So the private
respondent
respondent
subsequently
used
given two lease deed.
So this is the first lease deed.
Yeah. This is executed in the year of 2018, dated 5th April 2018. Now kindly see the lesser. Kindly the Srimati Momota Chatterjee, Srimati Momota Chattopadhyay, Joydeep Chatterjee, 2 and 3 Srimati Mou Mukherjee and Srimati Piu Mukherjee. They are the lesser in the lease deed. Kindly see page 89 once.
Yes.
Now they given a list to the in favor of the private respondent, Gautam Majhi.
Yes.
And kindly see the schedule of the property. Schedule of the property, page 93. Page 93.
22 acres of land.
Kindly see my contention 30 square meter equal to 98.42 feet. According to measurement. In the writ petition, in the paragraph of the writ petition, I have stated so. According to the measurement, 90 square feet will be 98.42 feet. Now kindly see the schedule and the north side 85 feet, south side 70 feet, west side 122 6 feet, 122 feet. If the frontage is, according to the frontage is south side 72 feet, it's a less eligibility.
Now you have said two deeds there.
And kindly see thereafter, I lodged a complaint before the respondent authority. Now they have rectified their fault by submitting another deed of lease. Kindly see page 111 once.
Yes.
Now this lease was executed by and between the Gautam Majhi, Pintu Mukherjee and Vijay Majhi leased out his land in favor of Songita Majhi, the private respondent hearing. And kindly see the schedule of the land, page 116.
Yes.
No frontage, nothing as kindly see in north agricultural land, in south agricultural land, in west 25 feet, in east agricultural land, and the same land. And kindly see the schedule. Now kindly tally the schedule of the property.
Now what is the schedule A property and schedule B property is there?
No, kindly see the first deed. Kindly see page 93 once.
Yes.
Page 93 once. They have given the lease deed in continuation of the earlier deed 2018. Here the schedule property is page 93. The first lease deed. District Bakura, PS Chatna, jail number 31, Mouja, Porashia. And kindly see plot number 901, total area 0.32 acres. Classification of which 0.22 acres of land. And kindly see the schedule, 85 feet, 72 in south, west 122.6 feet. And kindly look to 116 ones. Same schedule of property. Schedule A, kindly see Bakura, PS Chatna, jail number 39, Mouja Parashia, Ilar Khotian number, same plot number 901, total area 0.32 area, acres of land, out of which 0.22 acres classification of land. In 2018, the list given by the 4 lesser in favor of the husband of the private respondent. Now the private respondent, the husband of the private respondent subsequently executed it along with others in favor of the private respondent. Here I am joining an issue that a lessee cannot lease out the land. The husband of the petitioner is the lessee in respect of the lease executed in the year 2018. His name is, kindly see, his name is Gautam Maji, which is at page 111. Same lessee cannot lease out the land in favor of this of the petitioner. Lessees cannot transfer of the land in favor of the other person. So the contention of the deed erroneous. I am the lessee in 2018 deed. Subsequently, 2023, I leased out the property. It can be possible.
So you are challenging the title.
I am challenging the deed submitted by the private respondents, where there is a deficiency in the schedule and in the preparation of the recital part. Subsequently, it is erroneously registered. It cannot be maintainable. One lessee, if lessee has a right to lease out the property without consent of the lessor,
In the
then
second lease deed,
yes,
a schedule property was mentioned, which was the earlier given.
Same.
Thereafter, in B schedule, property was given by the subsequent lease deed, 5 decimal.
But kindly see the plot number, kindly see the jail number 39, LR Khotian number 579, because 2018, the scheduled property as a whole scheduled property is leased out as a whole.
No.
Because
why as a whole? Only 22 decimal. Out of total 32.
22 decimal. And kindly see the schedule A property 22 decimal.
Yes, that schedule was mentioned from earlier schedule.
From
earlier lease deeds.
My lord, from 22 acres of
this
land.
issue, whether this issue can be dealt with by this deed code, that is the issue.
They have to do their verification part.
I shall hear it out, them, no issue. But you are saying that the property which was offered by the private respondent is not to the specification of that.
But the eligibility criteria
specification is not there.
Yes.
The frontage is not 30. Let them hear out the matter.
Well, I have to submit.
Okay. So today we are out of time.
Well, fix another day. Tomorrow.
Only this issue or otherwise?
No, nothing.
Only this issue is there.
I'll take 10 minutes of your lordship time.
Very well. No, let him finish first.
Yes.
So I can fix it next week.
Yes.
Next week, very short issue is there, I think.
Yes. Very good.
My lord, may we file our affidavit in opposition? Respondent number 8, private respondent.
We have filed our affidavit in reply today. File kore diyeছিস তো?
Whether leave was granted to file you. Okay. এই 30 তারিখ কি আছে দেখো তো 30 তারিখ
আমাদেরটা দিবেন তো আমরা ফাইল করেছি এফিডেভিট ইন রিপ্লাইটা ফাইল করেছি আজকে yes that's
30
এটা ফাইল করে দিন
হ্যাঁ করে দাও
30 বুধবার সেকেন্ড হবে রেখে দিই
But we had taken out a application affidavit, my lord, for expunging the name of Union of India. But that formal order may be passed, my lord.
Okay. No, one whether any application is there or
My lord, we have taken out a supplementary affidavit, my lord.
আমরা পাইনি কপি কিন্তু জানো তো তুমি দেখিয়ে দাও no issue.
supplementary affidavit.
Yes, my lord. So there is a notification by the ministry, my lord, where
My lord, let a copy of the supplementary be given to us next date, my lord, your lordship will pass the
it
order.
They have served,
was-
I
it
think.
was been
No,
served. It was been served, my lord.
Yes, they have
not yet
on
served,
that
not yet
earlier-
served.
Earlier they have served, I think.
No, 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 my
I
lord.
directed you to serve them.
No, no, no.
They have not served. If
I have
not
not
served,
received.
Mr. Chatterjee served them.
Very well. If it is not, my lord, I believe it was been served, my lord.
Okay. Very well.
Well, it was what has been served as recorded in your lordship's order, my lord. Petitioner seeks accommodation to enlighten the court on this matter. It was served, my lord.
No, not served, not in my brief.
You have not received. I think on that day you have served a copy. I
Yes,
directed
in
Mr.
open court
Chatterjee
we
serve
did
a
it.
copy.
In open court
I
we
have
did
not
it.
Okay, if you not receive,
Yes,
it
yes.
Very well, we'll again serve it. That is no difficulty at all.
No issue. Okay, okay. That is not the issue here. So, your grievance against the HPCI, not
HPCL for
not the Union
issue-
of India.
yes,
Why the Union of India would part?
for issuing the letter of
Very,
intent in favor
very.
of private.
Lekho, please take down. দিয়ে দিয়েছো পিটিশনার কে দিন পিটিশনার কে
এটা আমাদের
ওই রে,
শেষমেশ এটা দিয়ে দিয়েছিস বাহ 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 গুড
affidavit in reply file on behalf of the petitioner to the affidavit of opposition file on behalf of the respondent number 2 to 4 is taken on record. Full stop. Next for affidavit in opposition file on behalf of the respondent number 8 is taken on record. Full stop. In pursuance to an supplementary affidavit file on behalf of the respondent number 2 to 4, it appears that the by virtue of a notification dated September 20th, 2019, Undersecretary to the Government of India has intimated to the oil companies to make specific application to the court for deleting the name of Union of India from the proceedings as a arrayed as a respondent. Full stop. In this matter, the Union of India is arrayed as in respondent number 1. Full stop. The grievance of the petitioner is against the respondent number 2 to 4. Full stop. The
and also the private respondent
main grievance is against the respondent.
answering respondent is
Yes. So, accordingly, the Union of India is not a proper party or necessary party of this matter. Thus, the name of the Union of India may be deleted, is hereby deleted from the cause title of the instant writ petition. Full stop. The petitioner is to take steps within a fortnight. Next part, argument on behalf of the petitioner continues. Let the matter appear in the list for further argument by the petitioner on 30th
Great.
of April 2024 at 2 p.m.
2 p.m. Yes.
Very nice. 30th.
Obligement, grateful, my lord.
Obligement. নাম দিয়ে এই নাম দিয়েছো আমার নাম বলে দাও না
Petition. What is the matter? Item number 28. 28.
Your Lordship,
Application.
28 application.
No, your matter you want adjournment.
Item number 2, my lord. Serial number 2.
2 p.m. fixed.
Application is
Matter,
served.
my lord,
Haven't served.
this
No.
ma'am is
Service
also
letter.
praying for adjournment on the ground of
Let
has
it
received
appear
children.
on 14th May, Your Lordship, as it is tagged with the another
Key,
case
read
there
up.
are two
Yeah.
read petition, my lord. And there is a direction of the division.
So item number 2 and 3.
Only
no.
2, my lord.
Only 2, Your Lordship.
Only 2.
Only 2. Narayan Chandra.
This
Okay.
state case is
There's a tag with one more.
Order to the order to the order to the
Item number 2. Let the matter appear in the list on 14th.
14th May.
another matter, my lord.
We
Another
tagged with some other.
Date बोलो.
Second last paragraph, Your Lordship.
देखिए Column, let the matter appear in the list on 14th May along with WPA. Which matter is appearing?
Lord, 3187, 3187.
Your Lordship, if, on the first page it's written Pradeep Datta.
7138 along with 71 WPA 7138 of 2025.
Along with all
Can
connected.
take Can take that.
All will appear.
Check.
All
Lord, my lord, it will appear on 2 p.m. 17 at 2 p.m. If you do.
14th May.
14th May.
হবে 7138 মেনশন ম্যাটার নয় দুটোই হিয়ারিং একসঙ্গে হয়েছে
বিশ্বনাথ দিকে এসো বলছি হ্যাঁ 14th কিছু আছে ওটা 14th ওটা রাখা নেই তো 713 মেনশন ম্যাটার আছে 14th May it was fixed as mention matter.
ওকে
Already it was mentioned as mention matter.
মেনশন ম্যাটার মিন্স ইট উইল বি অন দ্য টপ মার্ক
On the top.
Let me.
Under the heading mention matter. Under the heading mention. Yes, item number 28. What is the matter?
My lord,
28, Your Lordship, before my last
Application is there.
I am the petitioner.
Your Lordship, may I submit one thing? The application is what I presume from the service, it has been directly served upon the learned office of the government pleader. Your Lordship, in the writ petition, we were appearing led by Ms. Sonal Sinha. The application has not come to us yet. Apparently, Your Lordship, the matter was withdrawn. And thereafter, apparently he has filed a recalling application, but the application is not with me. It has not come to me from the office of the learned GP yet, Your Lordship. Your Lordship, in any event, the matter was withdrawn
My lord,
by the
my-
petition.
1 minute. My lord, my humble submission to your lordship that actually on 23/2025, they have from their office has received it. This is the proven
I do
document. After 1 minute, please let me complete. On received it, and thereafter can file and honorable court directed me to serve the erstwhile lawyer who submit before your lordship that petitioner does not want to proceed with this case. As a result, it disposed of. Honorable court has nothing to do. I have served him notice going in his office and he received it. That copy also here.
Who
So,
received it?
the erstwhile lawyer, Mr. Idrish.
Your Lordship, on the last occasion also it is recorded. Ms. Sonal Sinha and Ashmita Chakraborty was appearing.
No, no,
He is not arguing on your matters.
Exactly.
He is arguing his own matters.
Oh, in some other matter.
Then thereafter, my lord, they did not appear on last date. And now my humble submission before your lordship, everything I have mentioned in my CAN application. Neither any direction given by the petitioner. Petitioner did not know about it. So, and petitioner written it, petitioner daughter, minor daughter, She was in remote place in the village in West Bengal, in North Bengal. My lord, she does not know anything about it. And thereafter being compelled with folded hand, again she has come before your lordship that I have never said anything in this regard to say before your lordship by that lawyer. But a lawyer, why he has placed that submission? It is mysterious. More that I cannot do in the keeping in myself in the same profession. How he has placed this submission. That's why everything is written. And moreover, my lord, my folded hand, I have mentioned it in my application also. Honorable Supreme Court has said that for the fault of the lawyer, or his misdemeanor, or his inaction, or his fault, client should not suffer. He is a client. See now, no, nothing. 1981, paid 1,400. Honorable Supreme Court AIR. Honorable Supreme Court said. So in that light, my lord, kindly restore it. I have given the restoration petition. I have come before your lordship to have justice. Please do not return me from your door.
The issue is that Muhammad Idris was the advocate on record. He submitted before this court. Then
that is wrong submission, not instructed. I have written it in can application, my lord. Elaborately I have written everything. Please page by page you read it.
now tomorrow one will come and say that your submission is wrong.
My lord, but
That can be.
My lord, please, my lord, if evidently he has said, now he cannot come.
No.
Now you see.
That is not the issue here. Just I want to know whether the petitioner is debarred from file another affidavit to say that your submission is wrong.
My lord,
In
that occasion, what can I do? What the court shall do?
My lord, with folded hand, then give me punishment. Give me punishment. I am giving. The lawyer should be debarred from practice. This much up to that I can go.
Then this matter
Without
should be
hearing
have
the-
without a,
My lord, no.
then this matter should be referred to bar council.
My lord, this type of incident happened. That's why the Supreme Court passed this judgment. My lord, kindly consider.
No,
And the first
bar
time, my lord,
council देखा उचित ना
one thing
misconduct.
That cannot be
understand the
in absence of the
अरे
erstwhile
ठीक আছে
applicant.
दो जन আসবে सब रेफर করে দেবেন বার কাউন্সিল ডিসাইড করবে
one night from there 50 miles apart in remote village. Always can't come. He did not come on that day.
Look, I do not know what the issue with learned advocate and record and the petitioner is there. I do not bother about that. One submission was made on behalf of the advocate and record, that has to be accepted. Whether you filed any vokalatnama,
Yes, I have filed vokalatnama. Not only that, my lord.
where is the vokalatnama?
Then in can application, my lord.
Only Muhammad Idris vokalatnama, Muhammad Idris is there. Where is the vokalatnama? কোথায় vokalatnama কই?
दिखान
At the time of
और এখানে ফাইল হয় এইটা তো ডিপার্টমেন্টে ফাইল হয়
গভর্নমেন্টে ফাইল করে এসেছেন আমার লোক আছে বিষয় না কথা আছে
হ্যাঁ ও
আচ্ছা
আপনি দিল্লি থেকে আসছেন
Filing number তো
লোককে চিনেন এখানে
আরে না ফাইলিং নাম্বারটা দিন তাহলে
বাইরের লোক নই
না না তো আপনি তো বাহার থেকে
আমি মিথ্যা বলছি এই যে আমার টিকিটটা দেখুন আমি আজকে বিকেলে চলে যাবো
I am not asking you anything.
আমার ফাইলিং নাম্বারটা চাইতে
Okay, just wait. When you file the application, the date.
I have filed this application can my lord on 2nd March
7th March.
2nd March 2025
so
2nd
he
March.
has not written
Can want to
Where is the service upon the learned counsel?
এই যে my lord it is here
ক্যান তুমি কপি রিসিভ করেছো আমিও কপি রিসিভ করি
জিপি অফিসে সার্চ করেছি
হ্যাঁ
জিপি অফিস
File affidavit of service.
হ্যাঁ এভিডেন্স হবে
এই কই কই
না affidavit service কই?
হ্যাঁ হ্যাঁ সব কিছু করি
কোথায় অ্যাফিডেভিট কোথায়
my lord 1 minute I am requesting 1 minute I have
আমরা ছাড়ো
नहीं एफिडेविट देखना है ये नहीं देखना है सिर्फ सर्विस देखना है
पता नहीं क्या कर
ये जीपी ऑफिस में सर्च किया है क्या অরিজিনাল তো এখানে।
ना ना ये जो पोस्टर वाला है देखो, जीपी ऑफिस हैंड वाला देखो क्या।
हाँ हाँ
सिमरन
ये जो
मैटर चल रहा है, थोड़ा एक्टिव रहने की आवश्यकता है।
just only to state advocate, district controller, administrator, block development. This is not to the erstwhile advocate. This is not to the erstwhile advocate.
kindly password for 1 minute, my love. I'm just now few minutes ago I have seen.
Please.
কেন যে এরকম হয়ে গেল? She received it in own hand. আরে আরে এই যে
অ্যাফিডেভিট কোথায়? অ্যাফিডেভিট হয় না, না এটা সার্ভিস হতে
ওরা
পারে,
ঠিক করেছে নিজে হাতে।
ঠিক আছে, কিন্তু অ্যাফিডেভিট একটু করতে হয়, ঠিক আছে।
You have to file affidavit of service.
That will do.
Yes, you file affidavit of service after serving the copy of application upon both Miss Jahanara Begum and Muhammad Idris. Miss Jahanara Begum appeared led by Miss Idris, Muhammad Idris. You serve both the upon both the learned counsel and file an affidavit of service. Okay, and come.
Copy some पर भी सर्व कीजिए. No copy has been served on us.
না জিপি অফিস
GP office
বাট ওখান থেকে a copy may be given to us.
But
That is not the issue here. You have to file a affidavit.
okay, I will file it.
You have to file on affidavit.
It will sort it, and one submission, my lord, I have, if it is not irrelevant. And during passing the notice to the respondent, item number, respondent number 3, a pin code number is mistake. It is 130, it will be.
Let the writ be revived, thereafter it will be done.
Achha, achha.
Let the writ be revived first. Okay. Please take down. What is your name? Mr. Biswajit Nag,
हाँ, हाँ.
learned counsel appearing on behalf of the
Mala,
petitioner.
Chakraborty, my chamber,
Yes.
I am Manas Kumar Chakraborty.
You are
Manas Kumar Chakraborty.
Manas Kumar Chakraborty.
Vishwajit Nag
No,
is
no.
probably advocate on record.
We are both in my chamber.
Manas Kumar Chakraborty.
Ah.
Manas Kumar Chakraborty, learned advocate on record, submits that the application being Can 1 of 2025 is filed for recalling the order dated 26th of February 2025 passed by this court. By virtue of the order dated 26th of February 2025, this court has disposed of the writ petition as not placed according to the instruction of the petitioner of the writ petitioner as instruction of the petitioner as demonstrated by one advocate, Miss Jahanara Begum, led by advocate on record, Muhammad Idris. Petitioner is directed to serve the applications upon the learned advocates, namely Miss Jahanara Begum and Muhammad Idris, and file an affidavit of service within the returnable date.
And a lordship of copy can, whatever he has filed, if that is served on us.
Do you have a copy? You serve a copy?
I am
You serve them a copy. Learned counsel for the petitioner submits that. না কি বললাম নামটা কি মিস্টার Manas Kumar. Mr. Chakraborty submits that the copy of the CAN application was served directly at the GP office However, for the better appreciation of the matter, Mr. Chakravarti is instructed to serve a copy to Ms. Sonal Sinha, learned counsel appearing on behalf of the state. Within the meantime, let the matter appear in the list. May 6th, under the same heading.
6th May.
May 6th.
Oh my.
May 16.
Acha, Lordship, my 7th. 7th, if that
Seventh?
can be.
Yes, Wednesday.
Wednesday.
7th.
7th. Grateful, Your Lordship.
May 7th.
May 7th.
May 7th.
ঠিক আছে নাম্বার আপনি আমার জানেন
না আপনি জানেন না এটা।
Call item number 345.
ম্যাডাম এই নাম্বার
আমি দিচ্ছি আসুন
give the right matter.
For the petition, Lordship.
It will be taken up along with the hearing of this matter. I have started the hearing. Order is there. Yes.
My lord, I'm for the state. My lord, in this matter, I'm for the state in item number 4, my lord, which is WPA 30876. It was filed by Abdul Wahab. আমি item number 4 is stated.
Yes.
Just 4 number.
For state.
Yes. My lord, primarily the authorities had conducted a hearing pursuant to my lord's order, which has been very categorically stated that I'm not going into the details where the Abdul Rauf, he had objected to the licensee or to give the license to his mother. Thereafter, my lord, there was a series of litigations challenging each other's orders, and subsequently, by way of my lord's order, the authorities, the district authorities, had conducted a hearing. My lord, I'm led by Mr. Dotto in this matter.
Yes.
My lord has already considered Guru Pado's judgment. My lord is aware of the legal position. And now, first round of litigation, mother is approved, mother is granted the license. At the stage when the mother's name is approved, mother dies. Now, the situation changes after the death of the mother. So, primary license holder is no more there. And now, we are in a situation and their claim...
Now, whether license was already granted to them?
Approval was there.
Okay, approval was there.
Approval was there on the basis of this court's order in the single bench and as well as the division bench.
In favor of Minu Beva.
But Minu Beva expires. The premise of the brothers now making the application is on compassion. Nothing more, nothing less. They do not have an individual right. They only have a right arising from their father.
Yes.
So once father dies, mother also dies. Now the question arises whether compassion arising from the death of the father will exist or not.
Okay.
Your Lordship or this Honorable Court directs us to reconsider this on the basis of this changed circumstances. We reconsider it, call them, one appears, the other one does not, we reject both.
Yes.
On the day we conduct the hearing, one says one does not appear without any reason. One does not appear without any reason.
Says that he gets the letter.
Acha. When one does not appear without any reason, and one appears but says that he does not have the no objection from other brothers and sisters. So admittedly, neither of them had complied with the required qualifications for grant of license in their favor on the day of hearing even.
Yes.
Now, maybe one or two sisters have come forward saying that, yes, I am now granting NOC to one, not granting to other. That is an interstate dispute. We as a state cannot go into that. The primary concern for the state is that the initial license holder passed away in 2013. And today we are in 2025. 12 years have passed. We could not issue a fresh license because of this protracted litigation between the brothers and sisters. The localites of the area are being deprived of their valuable right of fair price shop. And we as a state, as a machinery to extend benefits to the local, cannot wait for eternity for the litigations or the contrary claims of a family. But we have to take a stand. We have taken and decided that yes, you may continue with your whatever interstate disputes are concerned, since your rights, the rights of both, we are not even siding with anyone. Either the petitioner in one, the respondent in other, the petitioner in the respondent in one has now also made an application, being the petitioner in another. So we are not siding with anyone. We say that because of your interstate dispute, the localites cannot suffer. We have cancelled both their applications and have said and have issued a notification for fresh tender. So that is the stand of the state, that since they do not have an independent right of compassion arising from upon the death of the mother, the compassion could have been from the death of the father, but not on the death of the mother. They say that since death of the father, the license was not granted due to litigation, mother died, so the right persists. Right may have persist or may not, but my lord, kindly visualize the situation. A person claiming compassionate grant of license cannot be said to have survived for 12 years without money. The question of, my lord, financial inadequacy cannot survive for 12 years. Both the families have survived, either this brother or that brother. Now they cannot say that they have financial stringency after 12 years of this protracted litigation. So state has to take a stand and consider the greater aspect, and have done so by rejecting both their applications and on valid grounds. Both were given chances, both were given notices. One did not appear by choice, or may have said that subsequently, whatever the reason is, and the other appeared but could not provide NOC.
Yes.
So that is the stand of the state, my lord, and the order, the under challenge in my humble submission should not be interfered with, and also the subsequent action of the state by which the notification has been issued for grant of fresh license in the area upon following all necessary requisite formalities and laws. Kindly grants us this liberty so that we can complete the procedure for grant of license. If my lord is at all pleased to entertain their rights or their interests, my lord can allow both of them to apply afresh in the new procedure which we have already floated. Both can apply. Whoever is fulfilling the requisite qualification can come in the zone of consideration and can be given a successful dealership.
That's all? Yes, thank you.
May I take your look?
Yes. No, reply first on by Abdul Wahab first. Thereafter your reply. Yes, I will give you liberty. Let them reply first. Thereafter.
Against both of them, I will give that.
Today.
Because of my another senior has relied upon some judgment I am looking. State time, my lord, I don't know whether state two matters, three matters are against state authority. One matter there appear. The first matter which we have filed after the death of my mother, what happened? There was a direction on there. There was a direction for inspection. The question of dependency is required to be ascertained by them. They did not do it. Whether this gentleman Abdul Rauf is dependent or Abdul Wahab is dependent. That question is required to be adjudicated in terms of the judgment, my lord, that the celebrated judgment, my lord, by of Guru. That was not taken into consideration. But the report is lying with the record.
No, just today. Whether are you ready?
No, that is why, my lord, I intend to come back, my lord, any day, my lord, accepting Thursday.
Well, 5 the state is appearing in.
State
Item number 5.
there, state lawyers are not prejudiced.
Well, at 4 and 5 state are appearing.
Arrector matter.
3. Probably.
Matter of Pritolal
Chatterjee
appeared on behalf of the state authority led by Shivsharno
Bondapan.
and that was taken into consideration by the Honorable Justice Vivek Chaudhary. There was a direction for supplementary affidavit. There was a direction for, my lord, inspection, inquiry not made in terms of the Gurupadur. That being the situation. So, my lord, whether state will come forward again or not, that will be a
No, state has submitted entirely.
kindly close it. And that was my, to some extent, I was with a little bit of doubt.
Let him argue first. Thereafter, you will argue.
Area I shall only require 20.
Because he wants to contradict your judgment.
Yes.
Let him argue first.
And one more thing, my lord, one application is pending. My lord, my learned senior had made filed allegation against the sister. These, my lord, applications, these no objection certificate, I think, forged, fabricated, and all this. Sister affirmed their affidavit, coming into the court and filed their application. That application possibly.
This application is settled to be heard along with the writ petition.
Yes, ma'am.
So I am heard, learned counsel. I shall hear you. No issue. I shall hear you also.
If this honorable
Petition
permitted by
for
the sister to ventilate their grievances.
I will permit them all. You just wait. Let the main matter be heard first. Okay, so when not Thursday?
Otherwise, any day. Tomorrow itself. It's not.
Already he will do it tomorrow.
If subject to lordship by the time.
Let it be closed. Finish.
টাইম হয়ে যায় আমার হচ্ছে
What about the
পরে করে থেকে PM আছে হবে না ফার্স্টে তো কিছু নেই 2 PM ফার্স্টে তো হবে না
Can out.
মানডে দেখো 2 PM এ কটা আছে
But he will take only half an hour.
কালকে
I will take only 15 minutes.
কালকে 3টে tomorrow 3 PM tomorrow 3 PM argument on behalf of the state authority concludes. Reply on behalf of the petitioner within bracket Muhammad Abdul Wahab continues. Let the matter appear in the list tomorrow at 3 PM.
Always recommend.
No. If their time permits, I can do that matter. Otherwise, how can I?
Deeply obliged, my lord.
Call next matter.
Lordship, item number 7, Lordship, Miss Monica Roy is appearing for National Highway, Lordship. Kindly give a short pass over. She is
Now
engaged.
pass over. I have 3 p.m. matter fixed.
Lordship, she is engaged in another court. Plus the.
Is for the petitioner. You are appearing for whom? For petitioner.
No, National Highway, respondent. And the petitioner is also not here.
Next document.
For the private respondent. Your Lordship may remember in this matter, we have filed an application under section 340 of the CRPC for committing forge by using forged document. But your Lordship's desire is to hear out the main writ petition first.
Well, I am for the writ petition.
Yes.
Well, the father of the petitioner, namely Abdul Mukhtar, was a fierce shopcom kerosene oil dealer at Borwa in the district of Murshidabad.
Yes.
He was running the said shop. At the relevant point of time, he had 3 sons, 3 daughters. The petitioner before your Lordship is first son. And Lordship, when the father was running the said shop, at the relevant point of time, the third son of the petitioner moved a writ petition before this Honorable High Court.
So you are Muhammad
I am
Shamsud Joha. You
My-
are the third son.
I am the first son.
First son. Elder son.
Elder son.
Elder son of the erstwhile MR dealer Abdul Mukhtar.
My lord.
Very well. Then
He had
who is
three-
the petition number 2?
My lord, petitioner number 2 is one of my sister,
Is one of your sister.
who is also claimant to this compassionate appointment of dealership.
So both of you want the compassionate appointment.
Both of us, the petitioners hearing.
How both of you can entitled to get the compensation of
Firstly, I made application. Subsequently, she made application also.
So there must have a separate cause of action.
Against her, my lord, there are some allegations made by the petitioner herein. My lord, firstly, at the first round of litigation, my lord, the Abdul Mukhtar was alive. Then the third son, Shamsul Kobir, who is no more at the relevant point of time, my lord, moved a writ petition before this Honorable High Court. My lord, obtain an order. Lordship, can come to page 21 to 24. The relevant page is, my lord, 25 is, sorry. Kindly see Abdul Mukhtar and another. Abdul Mukhtar was the father. Moved a writ petition before this Honorable High Court.
Yes.
That was disposed of by passing an order. Challenging that, my lord, I filed an appeal. Leave to appeal along with other applications. That has come on 15th March 2022, page 25.
Kindly see the relevant portion, page 28, my lord. Other applications were allowed, leave application, etc. Page 28, second paragraph. The allegation of the appellant that the writ petitioner, the respondent to in this appeal has an alternative source of income is an issue which falls within the obligation cast upon the subdivisional control in terms of section 20E supra. Mr. Shah, I submit that challenge to the deed of partnership will not lie. Oh, previous to that, my lord, one sentence should read. Page 27, my lord. Page 26, it starts. Mr. Chatterjee points out that the writ petition was filed by his father and one of his brother. It has been interiorly disposed of by the Honorable Single Bench with the direction upon the respondent or court in the writ petition to decide the representation of the petitioner number 1, the father praying for reconstituting the prayer price of from writ petitioner from sole proprietorship to a partnership by inducting the writ petitioner 2, that is other son and brother of the present appellant as a partner. Mr. Chatterjee submits that the prayer for reconstituting the partnership is violative of the provision of clause 20E of the amended public distribution system order 2013. It is submitted that the license can be converted into a partnership only if the family member proposed to be inducted or substituted as a partner or without a regular means of income. Mr. Chatterjee submits that the writ petition number 2 in this appeal has a regular source of income and such requires to be brought to the notice of the concerned subdivisional controller. It is further submitted that the deed of partnership is doubtful in as much as there are discrepancies connected to the age of the writ petition number 1, the father. Accordingly, the applicant pays for leave to file this appeal and the appeal being adjudicated a right of hearing before the concerned subdivisional controller arises, etc. Thereafter, my lord, page 28. The allegation of the appellant that the writ petition of this appeal has an alternative source of income is an issue which falls within the obligation cast upon the subdivisional controller in terms of 20A supra. Mr. Sahar, I submit that the challenge to deed of partnership will not lie before the subdivisional controller because the appellant is required to seek his remedy before the learned civil court. Mr. Sengupta, learned state counsel, submits that having regard to the clear provisions of the amended section of the appellant does not have an inherent right of hearing. Having heard the parties and considering the materials placed, this court is of the view that the decision-making process directed to be performed by the concerned subdivisional controller in terms of the order of the Honorable Single Bench can be better achieved in the event the appellant is also granted a right of hearing before the subdivisional controller at the time of deciding the issue. Accordingly, the subdivisional controller Kandi Murshidabad is directed to afford an opportunity of hearing to the appellant with production of documents, if any, while acting in terms of the order dated 13 January 2022, passed by the Honorable Single Bench. It is made clear that all points are left open to be decided by the subdivisional controller, since affidavits are not invited, all other allegations. Subsequently, recalling application was filed.
Who filed the recalling application?
My learned friend.
Yes.
That is Samsul Kovid. My lord, one of the order I have annexed, that is annexed P2, page 30, the last order of that application. In the same appeal, my lord, they also filed one 340 application, we also filed one 340 application. But that has been ended, that has not been ended because, my lord, kindly see page 31. Page 30, starts from page 30. Mr. Sengupta, learned senior complainant, appears with Mr. Pal, learned advocate, and submits that the original report as directed to be filed by the order dated Mr. Sengupta also seeks leave this court. Now, Mr. Leonard submits that a copy of the inquiry as directed to be furnished by the order that be served upon him. Accordingly, the state is directed to serve a copy of the said inquiry report on Mr. Chatterjee. Mr. Chatterjee shall be entitled to take an exception to the report by the next date. Let the matter appear for consideration next under the same heading, heard in part on 2nd of September at 2 p.m. Mr. Bhattacharya shall prepare a convenience compilation of documents necessary for consideration of the register shall be granted inspection of the said documents. This has not been done. Since then the appeal is pending and subsequently the appeal is infractuous. Why I am coming, my lord? So, my lord, division bench order is going on. And one thing, my lord, when the division bench is pending, he submits a document that we have already received, etc. To that's why I have annexed one document, annexure P3, page 32 and 33. There was a submission from the bar that they have already hold it. That's why I submitted a document. Page 32, my lord. Transparency portal, public distribution server, food and supplies department.
What document this is? This is a portal, copy of portal.
Portal. Website. Where, my lord? From the first one, FPS number, Abdul Farid Mullik, Abdul Mannan, Abdul Mukhtar. My father's name is there. Third column, first, second.
Third column.
My lord. From the gap.
Owner's name.
Owner's name.
Abdul Mukhtar.
Abdul Mukhtar, that is my father's name.
That is your father's name.
My lord.
So why you place this?
I am placing this at the relevant point of time. It was submitted from the bar that they have already got license. That's why I have submitted this.
So that is not the issue here now.
No.
Then what is the issue here?
My lord, the issue here is, my lord, subsequently, my father died.
Very well.
When my father died, I made an application for getting compassionate appointment.
Okay.
My lord, that is, my lord, death certificate I have annexed. That is annexed. Page 34, I have annexed the death certificate of my father.
Yes. Then what happened?
I made application with all documents, but my lord, the subdivisional controller asked me to file an affidavit. I also filed that affidavit. That is annexure 56, page 65 to 70. Filed affidavit. That is admitted fact. And in the meantime, Samsul Kovir moved a writ petition before this Honorable High Court. That order is lordship. And you see, with some prayers.
Where is the order?
My lord. Page 71, my lord. Learned Counsel appearing on behalf of the submitter, the petitioner would not like to place this application and would instead pray for a direction upon the respondent to consider the application for obtaining license for the fair price of dealership that was earlier run by him and his father in partnership. In view of the above, let the respondent number 5 consider the application made by the petitioner for appointment as a fair price of dealer and any other application. Kindly see, my lord. In view of the above, let the respondent number 5 consider the application made by the petitioner for appointment as a fair price of dealer and any other application that might have been filed in respect of the said dealership. Why this has been, my lord, I appeared on behalf of respondent number 6 and 7 when they praying for not place of the said application with the following order. Then, my lord, I intervened and I submitted that I should be given a right. Then his lordship Justice Joy Sengupta directed if another application is filed there, that should be heard analogously. Subsequently, my learned friend again filed a writ petition. No, sorry. Thereafter, my lord, as per the aforesaid order, hearing notice was given. That is page 73. When the decision was awaited after hearing as per the said notice, but in the meantime, my lord, my learned friend's client again moved a writ petition. That is page 74 to 80.
Yes.
Okay, 71. Yes. Lordship got it.
Yes, then what happened?
There, my lord, I have taken, my submission was not recorded, only in one place I accept. And I also submitted that he moved an another petition where he has not taken leave to move an same cause, same prayer. He again moved a petition that has not been taken into account by the honorable judge. That's why, my lord, I filed an appeal before this honorable High Court. That appeal, my lord, was pending when I filed this petition. Subsequently, I prayed leave before this honorable
Appeal pending, appeal you filed against WPA 16936.
My lord, I filed appeal against one 16963 of the 2023.
16963 dated 1st of August 2023.
23.
You preferred appeal against that order.
Against that order. But in the meantime, my brother, who was my opposite side, that is Samsul Covid, had died.
Huh?
Had died.
Expired.
Expired in a road accident. That's why, my lord, I did not praise that appeal. Subsequently, I withdrew the said appeal. And I made an application before the concerned authority. That is annexed P10.
Page.
My lord, page 81.
This is your application?
My application, stating that my brother had died, etc. আমার ভাই পথ দুর্ঘটনায় আলাদা আমার ভাই পথ দুর্ঘটনায় মারা গিয়েছে, এর জন্য শোকাহত। আমার মৃত ভাই পাইবার জন্য পিতার etc. I have written many things and I have also stated আমার মৃত করিয়া দিয়েছি। আমার কোনো আমার পিতার রেশনের দোকান বসে ছিলাম, তার প্রয়োজনীয় কাগজপত্র আপনাকে আগে জমা দিয়েছি। আমি আমার বিষয় সম্পত্তি দীর্ঘদিন আগে আমার ছেলেদের মোহাম্মদ শামসুল কবিরকে দানপত্র করেছি। দ্যাট ইজ মাই ব্রাদার who was my opposite side, Mr. Shamsul Kobir. I have gifted my properties to him also and my sons also, and thereafter I am dependent upon my father, etc. I have written there. And in support of that, all the deeds have been annexed. The assets of my deceased brother has been annexed. And another brother also gifted some properties to him. I also gifted some properties to Shamsul Kobir. All have been annexed. The deed has been annexed. So he has the sufficient regular means of income, and he has a crasher. He was a crasher of rupees 4 crore at Nishchintapur, Birbhum. Thereafter, my lord.
Crasher of what?
Stone cashing.
In the name of whom?
In the name of Shamsul Kobir.
That is your deceased brother.
Deceased brother.
So what is your prayer?
Now I am praying, my lord, before your lordships. Only I am surviving. I am.
Now you both of you made an application before the controller, subdivisional controller, for get license.
Subsequently.
Now that is page 81. Page 81 is your application.
No, previous to that I made application. After the death of my brother, we made application.
So what you want before
and
this
previous to
court?
that I made in prescribed pro forma compassionate appointment. When my father died, then the litigation was going on.
You not press this.
My lord.
Your prayer
But
is for issuance of license of compassionate appointment or fair price shop in favor of the petitioners.
My lord,
How the license can be granted in favor of two persons?
as my lord, my sister, there are three claimants. In one side,
No, you show me the law whether the license can be granted to two individuals. You show me the law whether a license of FPS can be granted to individuals separately.
No, we do not want separately.
That is your application.
As both of us, Lord, this is my first application. When my father died.
No, your prayer is otherwise. You see your prayer? You read your prayer in the writ petition.
Well,
you are not singly appearing before this court as a writ petitioner. Both of you have, you and your sister filed the writ petition jointly.
Yes, jointly.
And you are
jointly.
You are asking jointly the license. License cannot be issued jointly. There is no provision in the law. Can you show me the provision that license can be issued jointly?
Then, my lord, today, my lord, I will have to take time.
No, there is no provision, so far as my knowledge goes. Yes, anything?
My lord,
you read your prayers. Your prayers also saying that you want, both of you want license.
My lord, yes. I have prayed that before your lordship. And I will take one at a time, my lord. It is fact that I have prayed.
Yes, anything?
Lordship, kindly see page 35.
Both of you filed the application. 36 is the name of the applicant, both. How can it be? Where is the provision?
One at a time, maybe. Thereafter, I make my submission.
Okay, Mr. Sara, let me hear out Mr. Sara. Thereafter, I will give you one chance. Yes.
Well, this is the only point. It's not maintainable.
Mr. Sara, you are appearing on behalf of whom?
I am one of the son. Partnership license has been granted to me and my father. After death of my father, I applied for. In terms of the court's order, when the process was almost completed, my client died. Then my son applied for, and this is under process. Possibly, within a few days, license shall be granted.
No.
So far,
his wife.
Sir.
His wife.
Let him submit.
His wife applied for. Subject to consideration, so far this writ petition is concerned, twofold argument. Joint prayer has been made after death of my previous client. Prayer is to grant license jointly. There is no partnership deed.
Yes.
So on that sole ground, writ petition is not maintainable. It should be dismissed. In respect of this application, I have filed an application for 340 under CRPC saying that he is residing in Birbhum district. Control order says unless you resides in the particular subdivision, you cannot apply. I have annexed a document of his Aadhaar card, voter card, cell deed. He has denied it by annexing not a single document. He has admitted such position.
You filed application 340?
My lord.
No, no, I have already stated in my petition
Yes, you have
that
taken not a single document.
I have.
Kindly take up my application. Can number 2. That should be proceeded first, according to my understanding, because previously division bench held that there is a merit so far this 340 application is concerned, and we are going to proceed with the same. In the meantime, my father died. You will also kindly take up my application, can number 2.
Yes.
Page 7, paragraph 8, I am reading. Your applicant states that in the affidavit page of the said writ petition, being WP number so and so, filed by the writ petitioner herein before the Honorable High Court, Calcutta, it has been called. Can number 2. The writ petitioner herein before the Honorable High Court, Calcutta, it has been stated on oath that the writ petition number 1 herein has been residing at village Contempt, Post Office, Nabodurga, PS, Barwan, District, Murshidabad, being so and so. In the first paragraph of the said writ petition, it has also been stated that the writ petition number 1 herein has permanently been residing at the address given in the cost title of the petition. The said writ petition has been affirmed by the writ petitioner number 1 herein by stating that the content of the paragraph number 1 of the said writ petition is true to his knowledge. In the cost title of the writ petition, permanent resident of the writ petition number 1 herein has been written at village Kanta Swanso, district Murshidabad. Your applicant states that the writ petition number 1 herein, along with his family members for more than last 10 years, have permanently been residing at village Indrapolli, Shuri, district Birbhum. Your applicant states that the said writ petition number 1 herein has business of crushing of stones into the stone chips and modern and well-equipped machines, and from the said business he earned huge amount of so-and-so. Your applicant states that under the provisions of the so-and-so control order as amended, no person residing outside the subdivision where the dealership is set up or to be set up can apply for appointment as fair price shop dealer. Your applicant states that for grant of the said fair price shop dealership license on corporation ground, in place of the deceased dealer by committing fraud, writ petition number 1 herein in the state writ petition being number so-and-so has stated that he is a permanent resident of village so-and-so. Above statement as stated by the writ petition number 1 herein in the state writ petition on oath is totally false and untrue. Your petitioner states that your petitioner could collect some evidence which corroborates, substantiate the statement stated herein in following paragraphs. Your applicant also states that the writ petition number 1 herein by executing a registered deed of gift, executed and so and so with the additional district sub-register Panchmiri, Murshidabad, gifted his some landed property to his son so and so. In the said registered deed of gift, resident of the address of the writ petition number 1 herein had also 2 sons have been written by Indrapolli in the district of Birbhum. It appears from the said deed of gift that the value of the said gift was rupees 20,75,854. It further appears from the said deed of gift that the occupation of the writ petition number 1 is cultivation, whereas in the affidavit affirmed before the Honorable High Court, writ petitioner says occupied is unemployed. The said deed of gift executed so and so, voter card so and so, and his 2 sons have been enclosed wherein the permanent resident of the writ petition number 1 has been written in village Indrapolli, Birbhum. Xerox copy of the residence address so and so. Then all documents I have annexed. What case I have made out in the writ petition, in my application, that under the provision of Control Order 2013, a person who is residing in a particular subdivision can only apply for. In this case, admittedly, he is residing in Birbhum district. Only to get the license, an affidavit has been affirmed. I don't know how the commissioner has affirmed it, because at the time of affirmation, Aadhaar card is required. I have annexed the Aadhaar card of my learned friend's client, which shows he is permanently resident of Birbhum. Now, your lordship, kindly see the documents. Some documents I have annexed. It's a serious allegation. I shall show to your lordship the division bench order. That should be proceeded with. Kindly come to first, my lord. Page 26. This is a deed of gift of 10th August 2018, registered before the additional district sub-register, Pachmeri, Aurangabad, 10th August 2018. Kindly turn the page. Grohita Badroj Joha is the son and Data son of my litigation client, and Data Shamsud Joha. Kindly take the address. Thana Shiuri, Jela Birbhum, Indrapolli. This is his recording. His son, both of us residing in the district of Birbhum. This is a 2018 registered deed. Well, kindly turn the page. The price of the fourth, fifth line, he is saying that he is unemployed. He sold out this, he gifted this property 23,75,854. Have you also got, my lord? Now kindly come to my lord. Page 43 of my application. Kindly see, my lord. Voter card. Mohammad Samsud Joha. Middle portion. Address Novopolli, Shuri, Birbhum. Middle portion, my lord. Take note of, my lord. Indirapolli, Shuri, Birbhum. Have you also got, my lord? That I have shown from the registered sale deed also. Deed of gift, sorry.
Yes.
Then kindly come to page 46. Major information. Page 46, first table, second table, name and address. Mohammad Samsud Joha. Middle portion, Indrapolli, Shuri, district Birbhum. Have you also got, my lord? Then third column, Mohammad Badro Joha, son of Samsud Joha, Indrapolli, Shuri, Birbhum, district Birbhum. Can kindly turn to page, my lord, 55. The order of the division bench. In the previous postings, I have also filed an application under section 340 of the CRPC for committing fraud with the court. Affirmation before the Oath Commissioner saying I am resident of Murshidabad. Document says he is permanent resident of Murshidabad. Birbhum. Kindly take note of page 55.
Yes.
Parties are represented in the order of their names. By an order dated so and so, this appeal and the concurrent application were disposed of. On behalf of the private petitioner, two applications filed, which are as follows. Can number so and so, application for recalling of the order. Can number 5 is an application for recommending proceedings under section 340 of the Code of Criminal Procedure as amended against the appellant. Mr. Shengoto Lanet so and so, Mr. Shengoto so and so, then Mr. Chatterjee Lanet Council appearing for the so and so. Both has rejected copies of their. Mr. Chatterjee submits the time be granted to the appellant number 1 to the two application to respond by way of counter affidavit. At this stage, this court cannot refuse the party against whom proceedings is sought to be initiated under section 340 of the on opportunity of mid so and so. Accordingly, the appellant is permitted to file counter affidavit, late affidavit so and so, let the matter so and so. Although Mr. Chatterjee submits that neither the application for recalling nor the application for recommending proceedings under section 340 CRPC being can number 44 so and so respectively above are maintainable, this court is not in a position to accept such submission at this stage. Being otherwise prima facie satisfied, kindly take note of division bench that the facts and grounds pleaded in both the applications require such application to be adjudicated on contest. In view of the prima facie satisfaction of the division bench, as noted above, this court directs that the subdivisional controller Kanti Musta shall not proceed with the hearing. In his writ petition, a direction has been given to provide opportunity of hearing to my learned friend's client. That has been stayed by the division bench after considering my 340 application. Subdivision Kanti Musta shall not proceed with the hearing as directed so and so. Why? Because in that writ petition, he makes all those forged documents. So when I brought it to the notice of the court by a filing a 340 application, court understood prima facie satisfied that order which has been passed in the previous writ petition should not be given effect to. Because by a forgery, this order has been obtained. Apart from my first submission that jointly writ petition cannot be filed, there should not be any prayer for grant the license in the name of two persons. There is no such permission. But I want to proceed my 340 application first. He has filed an opposition to this. Not a single document has been annexed. People have to kindly take up their opposition to the 340 application. It is a settled principle. Every pleading should be supported by documents. He has only denied, no, I am residing in the Murshidabad. Not a single document. This application should be proceeded first. Kindly take up, my lord, their opposition in respect of my lord can number 2. But affirmed on 18th February 2024. Very thin one, because there is no annexure. What is the statement? Kindly take note of.
Yes.
Have you also got it, my lord? Mr. Samsudjua so-and-so, that I am the petition number so-and-so, swear and affirm this affidavit. Then next page, page 2. That a copy of the application under section 340 of the Code of Criminal Procedure has been served upon our learned advocate on so-and-so. I have gone through the same and understood so-and-so. With regard to the statement made in so-and-so, I make no comments as a so-and-so. With regard to the so-and-so, with regard to the statement, I make no comment. Then paragraph 6. With regard to the statement made in paragraph 6 and 7 of the affidavit, you will also kindly take up my application paragraph 6 and 7, just for a moment, side by side. What I have stated. Then, my lord, kindly take up. In this regard, I further state that the category of priest and state of our deceased father, who was the actual donor, so-and-so, namely Samsul Kobir, has already expired. His legal heir, so-and-so. Kindly take up, my lord, paragraph 7. He has dealt with, my lord, paragraph 8 and 9 of my application, which I have just placed before your lordship at page 7 of my application. Specific allegation. With regard to the statements made in paragraph number 8 and 9 of the said application, I deny and dispute each and every allegation made therein, 7 except what are matters of record. In this context, I further say that I born at village Kanta and I grew up Kanta. But sometime for maintaining my livelihood, I gone to Sri Bolibhum, where something lived at Kanta with my father, and sometime I lived in Suri Birbhum. But subsequently leaving all properties at Suri Birbhum, I permanently lived at Kanta, Murshidabad with my father after donating my landed properties to my brother, namely Samsul Kobir, that is my client. Since deceased and also gifted some other property, along with lands of my sons and peaceful along with wife, who is the lead petition number 2 herein, solely dependent on my father's income since long more than 4 to 5 years ago, and as such, Aadhaar card was also issued in my name, and the Pradhan of the concerned Gram Panchayat has also given certificate to the so-and-so. The lead petitioner craved leave to refer the so-and-so. Kindly take note of, my lord. Aadhaar card has not been annexed. Let him produce first the Aadhaar card, showing that he is the permanent resident of Murshidabad. He is playing fraud with the High Court also. How it has been affirmed without any Aadhaar card? It is a duty of the Commissioner of Oath to affirm an affidavit only on satisfaction that he is the permanent resident of the location which has been disclosed in the application. Not a single document. Kindly see the first page, what he has stated, why he is residing. First page of the opposition, my so-and-so residing at village so-and-so, district Murshidabad. How it has been affirmed? He is unable to annex the document of Aadhaar card, voter card, any single document. That should be proceeded first, my lord. First of all, he has played with the Commissioner of Oath. Now he is playing with the court also. By saying that I am till now is a permanent resident of Murshidabad. How he has affirmed it? An investigation should be conducted. Some steps should be taken. No denial, no documents, nothing.
Only in this score, my lord, I should make some submission. Have you finished?
The provision of the controller order is very specific. For dealership, the person who applied for must be a resident of the concerned subdivision, and in respect of distributorship, he must be a resident of that particular district. This is the case of fair price shop. He should be a member of the concerned subdivision. He is not even a resident of that district even. Sale deed, voter card, Aadhaar card, everything I have annexed.
Yes.
This is his reply. He cannot make out a further case. Entire pleading is wrong. Partnership with my father. After death of my father, I moved this appellate court. Court directed to consider my application for continuation of my business as proprietorship. He says in the writ petition, never license has been granted to the partnership firm. I have annexed all the documents. If your lordship kindly take up my application for addition of party. My lord, can page 46, just for a moment, for my satisfaction.
Can one?
Can one?
Can one was disposed of?
Disposed of, but just one document, because I have annexed more documents in my application. First paragraph, last 4 lines. This is the order of the subdivisional controller. Page is not so legible, page 46.
Yes.
Just I'm reading from bottom 3rd paragraph, sentence starts 4 lines. If no eligible, have you lordship of my lord?
Yes.
If no eligible family members found to be become the partner or partners as the case may be of the said partnership firm, kindly take note of. I, along with my father, has been running the said dealership business as partnership firm. The survival partner may apply for the conversion before the licensing authority, and upon satisfaction of the licensing authority, the said son, surviving partner, will be allowed to continue the business of the sole licensee as the sole licensee approach so and so. It has been addressed to my client. After my application is the observation of the subdivisional controller. If you apply separately for conversion of the license from partnership to proprietorship, you can do it. Accordingly, I made the application. My lord, kindly turn the page 47. With all documents and papers. An inquiry has been conducted at page 57. Only in respect of my application for conversion of partnership license to the proprietorship. Kindly take note of page 57. What is the name of the partnership firm? Enclosed, please find here is the file comprising of personal performance C3, application along with so and other documents regarding the conversion of the partnership license of fair price bearing so to sole proprietorship in favor of Abdul Kabir, that's the existing sole partner of the partnership firm, in the name of style of Mrs. Abdul Mukhtar. What he has made out the case, father died, I applied for, he also applied for compulsory appointment. This is not the case at all. This is a case where I have been advised by the subdivisional controller, since there are no other applicants, you may apply in the prescribed form for changing the status of the business from partnership to ownership. And that I have done. Then inquiry has been conducted. Now he has lodged a complaint at page 58. Kindly take note of my lord, page 57, then my lord, his objection, page 58.
And only the opposition. Opposition করছো না additional party করছো? Additional party কত বললো তুমি?
Then my lord, hearing has been taken place at page 91. Selection process has been concluded. In the meantime, the husband of my present client died.
Additional party application আছে? Additional party.
Yes.
Now kindly take up the license which I have annexed in my opposition also. Page wala just I am placing before your lordship. Now kindly turn to page 43 of that application. How he has made out the case. This is the license granted to the partnership firm.
Page
43. of can number 1,
Page 43.
43, Annexure C. First, the partnership, name of the partnership from Mrs. Abdul Mukhtar. Have a look at my lord, page 43.
Yes.
Then name of the partners, Mrs. Samsul Kobir, that is the deceased father, and Abdul Mukhtar, the deceased husband name of my present client. His case is not this license has never been granted. Since the one of the partner, surviving partner, made an application that was under process. Just before granting license to my previous client, he died. Now I applied for as widow. Since my husband was one of the partner, what right he acquires? Brother does not come within the purview of family member. Sister does not come within the purview of the family member. Rather, they come within the purview of my relative. They have debarred. I am not going on marriage. My first submission, once again repeating before your lordship, proceed with the 340 application. They have no right, so far the law is concerned, but I want to proceed against them under section 340 CRPC. My husband died. I am the spouse. I applied for license should be granted to me. There is no NOC is required. They have no claim even.
Yes.
These are my submissions.
Lordship, only in respect of 340, today I am just trying my level best to satisfy your Lordship. Lordship, kindly take my reply about 340, paragraph 7. My learned friend already read it. Paragraph 8 and 9 of the said application, I deny and dispute each and every allegation made therein 7 except total matter of record. Paragraph 7, page 3 of my reply.
Yes.
In this context, I further say that I born at village Katna and I grew up at Katna. But sometimes for maintaining my livelihood, I gone to Siuri Birbhum. When sometimes lived at Katna with my father and sometimes I lived at Siuri Birbhum. But subsequently leaving all properties at Siuri Birbhum, I permanently lived at Katna Murshidabad with my father after donating my landed properties to my brother, namely Shamsul Kobir, since deceased, and also gifted some other property along with lands to my sons and presently along with my wife, who is the writ petition number 2. Herein was the solely dependence on my father's income since long more than 4 to 5 years ago. And as such, Aadhaar card was also issued in my name, and the Pradhan of the concerned Gram Panchayat has also given certificate to that effect in my favor. This is my contribution. But as it is private document, I should not annex it. That's why, my lord, I have annexed.
What private?
But Aadhaar card is my private document. I am handing over this to my to my lord.
Now you have said that the petitioner crave leave to file the other card.
My lord, that is with me, and if your lordship asked me, I can produce also original.
Yes, you file it. You file it with affidavit by a copy.
Affidavit by copy?
Yes.
As your lordship granted leave, then my lord,
Very good.
voter card also I can annex. So I have not holding that is not correct. As it is private document, that's why, my lord, I have not annexed. If your lordship grant me leave, I will file and I may supply a copy of to that.
Very good. So what? And within 7 days?
Coming week, my lord, I will not be here. On the previous day, I said,
I got the same
mother's yearly search ceremony. On the previous day, I have said, only then, my lord, coming week, I have some difficulties. Otherwise, lordship, any day as your lordship convenient.
5th of May?
10th of May.
5th of May, Monday.
5th of,
Please take down.
instead of 5th of May, 6th or 7th, I will come, my lord, thereafter I affirm this affidavit and hand over.
Very well, come on 6th then.
মা
6th of May.
এখন কেন দেবো তোমাকে এফিডেভিট করে দেবো তুমি খুব বলেছো
Very well.
আমাকে অ্যাডিশনাল পার্টিটা দাও না আমার কাছে নাই
Argument on behalf of the
লর্ডস ইজ অনলি ওয়ান প্লেয়ার additional party application is not with me because I have not
I'm handing over.
objected to that allowing his application and kindly give I have
আমার কাছে কপি নেই আমার কাছে
এই
কপি
ওই কাছে আছে একটা তাহলে জেরক্স করে দেবো নাহলে
আমি জেরক্স করে দেবো
না আমি দেবো
Very well.
আমার মুখ সলভ না
Argument on behalf of the petitioner
কালকে দিয়ে দিস
as well as the private respondent concludes.
আমার কাছে কপি নেই
Petitioner intends to reply against the argument. Intends to reply. Accordingly, the matter be fixed for further hearing on 5th of May or 6th of May 2025. Full stop. Leave is granted to the read petitioner to file Aadhaar card and documents thereon appertains to mention in paragraph 7 of his affidavit in opposition against the application under section 340 of CRPC filed by the respondent number 4-6. You have added respondent.
added respondent.
By the added respondent. The petitioner is directed to file the documents along with an affidavit by supplying an advance copy to the added respondent on the urgent date. Fifth May, 6th May, 6th. 6th.
কপি নেই
as per your lordship's directions we have already served a notice upon state previous session lordship directed me to serve a notice but today is also not happening.
কে আছে কে আছে
I have already complied with your
কে আছে
lordship
দেখো
order.
এটা কেন?
Shisham.
In spite of service of notice, none appears on behalf of the state respondent. Let the service of notice through the letter of learned counsel be taken on record.
further notice may be given to Mr. State Advocate. That will be
Petitioner is directed to
proper
serve a notice regarding the serve a notice upon the states regarding the urgent date.
to the State Advocate.
ঠিক আছে
I will grateful my lord.
Same fixed matter.
Your Lordship, item number 7, I am for the petitioner, Your Lordship. I was actually having my legs in front of court number 19 and due to the technical glitch, the display board was not properly functioning. I just missed the matter. I am praying for this, not this week. I'm led by Mr. Arindam Das. I'm
For the
praying
for the petitioner.
for the petitioner, Your Lordship.
What you want?
I'm not this week, Your Lordship.
It was specially fixed matter, not this week. That cannot be done like that.
Lordship, he is out of station due to some medical emergency, Your Lordship, personal. Kindly fix it next week, any day, Your Lordship.
কি আছে দেখি? May দিয়ে দিন 13 মিনিটে কি আছে? Huh? 2 p.m. Item number 7, an accommodation is sought for on behalf of the petitioner. Let the matter be urgent today. An accommodation is sought for on behalf of the petitioner. Let the matter be urgent today. Release the matter on 13th of May at 2 p.m.
Grateful, Your Lordship.
Call the fixed matter.
I am appearing on behalf of the advocate. I am on behalf of the petitioner. Let me meet the sir.
This is a matter
The last occasion,
where the allegation has been made against the dead person.
in the last occasion, I have cited so many judgment as regards the suppression of the facts. But at the judgment, mainly the petitioner who came before who suppressed the material fact, that point is there. So your lordship advised me to place a judgment where the respondent suppressed the material fact, observation of the court is in the same way. Before I have last occasion, I have also handed over the written arguments of the notes.
Yes, it is with me. Today is for reply only on the
Yes,
point of law.
yes, your lordship, on the last occasion, I have cited so many judgments as regards the suppression fact where the court is serious and replicated that kind of suppression of the fact. But as the judgment, most of the judgment mainly as regards the writ petitioner. So your lordship advised me, let me want to see where the respondent suppressed the material fact, objection in the same way. I am citing the judgment of
No, you first show that the respondent has suppressed the material facts before the court.
yes.
Where is the fact?
Where is
What
the
fact they have suppressed?
Yes. 2007.
No, that I know. Everything no. You show me from pleadings that respondent had suppressed a material fact before a court of law.
Lordship, kindly come to the writ petition. Page 46, annexure P6. Got it? Order of my Lord Justice Bag in the earlier writ petition. Page 46, annexure P6. The petitioner filed a writ petition paying for direction upon the respondent to consider the series of representations submitted by the petitioner, annexure P8 and P9 and 11 to the writ petition. It is contended on behalf of the petitioner that the petitioner submitted series of representation before the respondent number 3 for tagging ration card with the cooperative society as fair price of dealer without tagging the same with the respondent number 7. But the said respondent have not been considered by the concerned respondent till the date. The next, Mr. Banerjee, London Advocate Standing Counsel representing the state respondent submits that the presentation of the petitioner may be considered by the respondent number 4. Next, Mr. Saharai, London Counsel representing the respondent number 7 submits that respondent number 7 should be given an opportunity of hearing at the time of consideration of the representation submitted by the petitioner. When he made the submission before the court on 3rd August 2017, but the writ petition filed by the private respondent in the year of 2007 that has not been disclosed here. If the said had disclosed here, then the matter should be ended in that writ petition. That will not come again. But that was not disclosed. That is the suppression of the material facts which the petitioner came to know on October 2023 before the hearing of sub-regional controller. I have stated in my writ petition paragraph
So you are saying this is the suppression?
Yes. 2007 writ petition moved by him. Against whom, on the basis of the representation, district controller advised the sub-divisional controller to take step. And for that reason, the district controller,
Very well, you show me the judgment.
district controller straightway
You show me the judgment.
conceal the essence of. That has been challenged by the private respondent, that without following the procedure of distribution control order, that has been cancelled. So that cancellation order set aside with liberty to the respondent to take appropriate steps as per the provisions of the law, but without taking any steps as per the provisions of the law, with connivance with the licensing authority, the private respondent has been enjoying the license since 2007 till the date. I have cited so many judgments as regards the suppression of the facts.
Yes, show me the judgment.
I am saying. Copy of that date I have handed over to my lord, that has been returned back to me. As regards the petition suppression of the facts, but your lordship wanted to know where the judgment shows that if the respondent suppress the material, that is also applicable in this case.
Yes, citation does it.
195 Supreme Court 1421.
Give me a copy.
Yes. Yes, the model judgment.
Page copy is 95
1421. 421. Yeah. Before Kuldeep Singh and B.L. Hasan Adia. I did him the page 422, paragraph of the bottom, the last paragraph of that, before the last paragraph, to enable the court to word of got it, to enable the court, got it, Lordship?
Yes.
To enable the court to word of unjustified interference in the working. Those who indulge in immoral acts like perjury, prevarication, and motivated falsehood have to be appropriately dealt with, without which it is not possible for any court to administer justice in the true sense and to the satisfaction of those who approach it in the hope that the truth will ultimately prevail. Anyone who takes the course of thought, reflect the course of judicial proceeding, or if anyone is done, if anyone. So there is the parties who appearing in that matter, it is applicable. Anyone who takes the course of thought, reflects, and if anything is done with objective motive, the same interferes with the administration of justice. The word interferes means in the context of the subject, any action which checks or hamper the functioning or hinders or trains to prevent the performance of duty. Obstruction of justice is to interpose obstacle or impediment or to hinder impediment or in any manner interrupt or prevent the administration of justice. If the course of falsehood is taken with objective motive, same would definitely hinder, hamper, or impede even flow of justice and would prevent the court from performing their legal duty as they are supposed to do. I am.
Okay, give me a copy. This book cannot be taken. No, give me a copy. This book cannot be taken.
I copy my letter. There is some marking.
You give me a fresh copy.
Yes, copy.
You give me. You can give me the marking copy also. No issue.
So, no, there is another so many points. Not only the particular paragraph, there is the other paragraph also.
No, I shall read it.
I said,
read it. No issue. You have marked it.
yes. That's it. While it come to page 4 to 3, marking there.
Yes.
Polluters of justice, judicial firmament are required to be well taken care of to maintain the sublimity of courts and environment. So also to enable to administer justice fairly and to satisfaction of the concern, third person are required to be properly dealt with, not only to punish them for wrongdoer done, but also to deter others from indulging in similar acts, which take the faith of people in the system of administration of justice.
Okay.
There is other point.
Not necessary. Not necessary. You do not to argue. I shall read it.
In case of the respondent, there is a judgment of the court or the not. One of the judgment. Another judgment I am citing. 2022 Supreme Court cases 5-2. 5-2.
Supreme Court cases হয় না
SCC
2022 SCC
22 SCC. In that judgment, my lord, I am reading page 53, my lord. Held. Paragraph held. Making false statement is an offense under section 181 of IPC. Furnishing false information with intent to cause public servant to use its lawful power to injury of another person is punishable under section 182 of IPC. Cognizable offense thereafter another paragraph, next paragraph. Any person who makes attempt to receive court interferes with the administration of justice can be held guilty of contempt of court. Anyone who takes the course of thought, takes the course of judicial proceeding, or if anyone done with oblique motive or any publication with intent to deceive court to make the intention to defraud same is contempt, and it interferes with the administration of justice. Concealment of the material facts is jugglery, manipulation, innovating, or misrepresentation, which has no place in equitable and prerogative jurisdiction.
Very well. Give me a copy. Give me the copy, not the book.
There is no, I am reading thereafter. I am handing the Xerox copy there.
Give me the Xerox copy. You take the book.
Last, my lord, I am playing last. I am handing over the last paragraph. I am making a false statement on oath is an offense punishable under section. Here, my learned friend, being appearing on behalf of the private respondent, submitted. He should be given opportunity. Before that, steps were taken by the district controller and directed this license of the subdivision to take steps against the mass petitioner. So on the basis of that, when the statewide license has been continued, that was challenged before the court and set aside this cancellation order. That fact at the time of submission before the Honorable Justice, my Lord Justice Bagh, in the year 2000, that has not been submitted that is clearly suppressed, which hampered the majesty of the judicial proceedings and delayed the process by which the private respondent enjoying the license illegally since 2007 till the date.
Very well. Give me the copy of judgment. That's all?
No. That was here. Other so many points. And citing one judgment of the Delhi High Court,
For what?
where is the suppression fact and also truth is suppressed on the basis of that. Here the Delhi High Court, quoting the so many judgment of the Supreme Court, delivered this aspect. I am having a Delhi High Court judgment, H.S. Bedi versus National Highway Authority of India, passed on 2nd January 2016. অনলাইনে কপি বের করেছি আমরা। এটা পুরো নাম্বারটা কিছু বলেছি দিল্লি হাইকোর্ট এইচএস বেদি ভার্সাস ন্যাশনাল হাইওয়ে অথরিটি অফ ইন্ডিয়া কেস নাম্বার RFA 784 of 2010. Single bench. Yes, I am citing. Your Lordship, come to page 14 of the state judgment. 14 of the state judgment. 6.13. Side mark is there. Line mark on the side of that. Line mark is there. 6.13. Lordship got it?
Yes.
A party, whether he is a petitioner or a respondent or a witness, has to respect the solemnity of the proceedings in the court, and he cannot play with the court and pollute the stream of justice. It is a case like this which false claim or false defense. Kindly mark it, false defense.
No, in this case, there is no defense. There is no such defense.
So, my learned friend submitted before the my Lord Justice Bagh.
No, it says defense.
Defense.
Defense
So,
means
state
not the
defense.
submission.
State the defense and submit it before the
No,
court.
you take
It
it.
should be given a
No,
before
no.
that, already
You
steps
take it.
taken.
You take it. This judgment says the false defense should be there.
Yes, he takes the false statement, making suppression of the facts.
Defense is not the statement of the learned counsel.
7 facts he did not disclose.
No,
This
no,
is the
no,
defense.
no, no, that
This
is not
the
a.
defense.
I want the defense.
Defense.
You cannot show the defense.
Which lowered the course.
Okay.
Causes delay. So many findings in that judgment I have wanted to cite before your Lordship. Which lowered the course, causes delay, consume judicial time, and bring a bad name in the judicial system. The case is simple, where the facts are glaring. Even if we are not so glaring, once followed is apparent. Not the take action would be improper. There is next paragraph 8.7. Yes, next paragraph 6.16. 6.16, page 15. 6.16, page 15. 6.16. In an effort to redeem the situation, not only realistic cost and full compensation in favor of winning party against the wrongdoer are required, but depending on the gravity of the wrong, penal action against the wrongdoer is also called for, unless the judicial system protects itself from such wrongdoing by taking cognizance, directing prosecution, and punishing those found guilty. It it will be failing in its duty to render justice to the litigant, the citizen. Litigation by false claims and defense will come to be placed before this court, load and docket and delay delivery of justice to those who are genuinely in need of. Next is 8.7, making false advertisement in the pollute the system of justice. It is an attempt at inviting the court into passing a wrong judgment, and that is why it must be treated as an offense. So, by suppressing the material fact, suppressing the truth in question, which the matter should be dealt out, he committed the offense. If my London friend submit before earlier in petition 2017 before my Lord Justice Bhatt and disclose the fact of 2000, then the matter is ended on that matter. That matter will not come today. Today, by that way, my London friend misused the judicial process, has misled the judicial process and misled the honorable court to pass an appropriate and render justice to the litigant.
Very well.
There is so
That's
many
all?
findings in that judgment, my lord.
I will deal with that. No issue.
My lord, there is so many findings.
I will deal with that. Not necessary to.
No. Other findings is there.
No, I shall deal with that. I shall read the entire judgment. No issue.
No, other
You have
findings.
marked it. I have seen that. You have marked it. You have marked it.
Marking portion. So, your lordship, I expect at the time of delivery, the marking
Yes,
portion
I will deal with that. I will deal with that.
Vital point which should be draw the attention of my lord. That should be read out for my satisfaction, my lord.
Yes, you have to satisfy and you have to satisfy this court also to
Yes,
demonstrate this matter.
So, all points are in favor of the petition. If
Yes.
your lordship point
You
out,
just read it out. Read it out. Now I shall ask you a pertinent question here.
yes.
Why you are here
in
arguing
that
on this
judgment, in that judgment also it is stated.
Yes.
If your
Read out. No, not necessary to. You read out. What portion you want to read?
when you can't if your lordship is so high, how I can.
Mention me the paragraphs. That would be sufficient. You must be mention me the paragraphs first.
Page 51.
Page
51.
Page 51. Paragraph.
Section 125. Judges power to put question or order production. For that reason, your lordship asked me the question. So I am ready to answer the.
That is Evidence Act.
Yes.
That is Evidence Act. That is not required to.
What is the duty of the court that has been dealt out in that judgment? The judge may. Lordship got it?
Paragraph page 51.
Page 51. 51. The judge may. Lordship got it?
Yes.
The judge may, in order to discover or obtain proper proof of relevant fact, ask any question he pleases. That is, I want to ask my lord also. Say, if your lordship find any adverse point in favor of the put me question, I shall satisfy on that point. Ask any question he pleases in any form, at any time, at any witness, or of the party about the facts relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor the agents shall be entitled to make any objection to any such question or order, nor without the leave of the court, the cross-examination of witness upon any answer given in reply to any such question, provided that the judgment must be based upon the facts declared by this act to be relevant and duly proved. And also there is others point also. Lordship, kindly come to page 52. 15.6, page 52, 15.6. Paragraph start. It is highly important. Lordship got it?
Yes.
It is highly important that the judge should arm with full power, enabling him to get at the facts. He may accordingly, subject to the condition to be immediately noticed, ask any question he pleases in any form at any stage of the proceeding about the matter relevant or irrelevant, and he may order the production of any document or thing, or no objection can be taken to any such question or order, nor are the parties entitled without the court's permission to process even. Here I am pointing out, your lordships on that power as per the judgment, your lordship asked the private respondent, is there any whisper before October 2007 to 2023?
Not the facts, not the facts. I have heard the facts.
It is there. They have not disclosed. This is the main question to be discussed here. Whether the 2007 petition they have.
I have heard you, sir. Now ask me one question.
Yes.
What is your locus?
Locus. I am the mass petitioner. Some
Mass
of the mass
petitioners.
petitioners, and also not.
What
for
is
the
your prayer?
Not for the person.
What is your prayer in the writ petition?
Prayer of the writ petition.
Whether this prayer is maintainable?
The written nature of matter was commonly of the respondent, mainly the respondent number 4 as to why the approval of decisions are not granted in favor of the private institution. A bias to it. Not be cancelled after state decide the direction to approve the state decisions of the name of the. Yes, this is the claim of the mass petitioner in the mass petition. As the earlier Samavai Committee went into liquidation, that is the input.
So you want the license be approved in favor of Srikantia Samavai Krishi Unnayan Samiti. Who are you? Who are you?
Input as the
No, who are you? Are you a member of the said Samiti?
Yes. Writ petitioner are the member, and also mass petitioner are the member of the said committee.
Whether you have pleaded so?
Yes.
Where you have pleaded that you are the member of the.
This is the, my lord, this is the technical question.
No, whether you have pleaded. No, you have not pleaded.
If my
You have not pleaded.
is haltering here and there, not go to the merits of the case. As there is,
I have heard the merit. I have heard the merit.
As there is no merit
No,
of the
no,
case.
I have heard the merit. Oh, you are arguing otherwise. I have heard your merit.
Yes.
Now I am asking you a question. For deciding this matter.
Yes.
Whether you are a member of that Samiti.
Yes, yes.
Have you pleaded it? Not pleaded.
This is the main question. This is
No, I know the main question.
Locus. I have my argument pointed out the same.
Very well.
Being in the member,
Okay, hard.
mass
Okay.
petitioner are the members.
Okay, no more. I have heard it. I have taken your written notes of argument.
Yes. So
And the judgments?
what I am submitting before passing the judgment which is cited, that should be quoted.
Yes, I should quote all the judgments.
And also the RS Bedis case, I am at my HS Bedis case versus National High Authority, which which have had a side mark is there.
Yes.
Side mark is there. This is the vital importance that has been there. So you lordship quote the judgment.
No, issue is that when you cite a judgment, you must mention the paragraph numbers. You have not mentioned it. That is the difficulty.
Wanted to submit.
This is the difficulty for me.
I wanted to.
However, I will deal with that. No issue. I will read all your arguments. Please take down.
I shall hand it over copy to my lord. So
okay, please take down. Argument on behalf of the parties concluded.
One page ballot notes of argument.
Okay. Okay. Parties are at liberty.
My prayer allow our interpretation in terms of matter. In terms of prayer.
Very well. কি বললাম বলো?
My lord, possibly we are not opposed. And just one thing, actually.
Very well. কি বললাম? Argument on behalf of the parties concluded made CAV. Parties are at liberty to file written notes of argument within
If you handed over me the copy, I shall give the reply of the said
within 2
judgment,
weeks.
pointing out the points of law. My lord, Landed Fair wanted to submit a written argument. If you handed over me, say, I shall take 5 or 10 minutes to argue on that point.
No, argument closed.
What my Landed Fair submit?
I have allowed both of you to file a written notes of argument within a fortnight.
Yes, I have already handed over in the earlier occasion.
If you want to hand it over again, you can hand it over.
Yes.
Okay. No. CAV. Made CAV. Not. It will not appear.
One page I shall give them.
Okay. Call next matter.
I shall also hand it over the judgment.
Second note support.
Yes.
Second note support.
দেখো
The lordship, the petitioner does not want to proceed with the matter. Action related to supplementary.
supplementary affidavit.
Annexing the instruction. They do not want to proceed with the matter.
Are you the advocate on record? Please take down. Supplementary affidavit filed on behalf of the petitioner taken on record. Full stop. Ms. Sohaili Mukherjee, learned counsel on record, appearing on behalf of the petitioner, submits that the petitioner has shown the supplementary affidavit with proper written instruction containing inter alia that the petitioners are not intending further to proceed with this matter. Let the supplement, she submits that the necessary order may be passed. Having heard the learned counsel for the parties on perusing, full stop, on perusing the supplementary affidavit along with the written instruction of the petitioners, let the writ petition being WPA number 3138 of 2023 is disposed of as not pressed. Next. No one is there? We mention next.
Lordship, I appear for the petitioner at item number 24.
Yes.
Nobody is appearing for the respondent. Lordship, yesterday in the second half, we have received the opposition which has been filed by the private respondent in regard to the supplementary affidavit which was filed by us. Lordship could fix a date in after a week, Your Lordship, we can file a reply to it.
Learned counsel appearing on behalf of the petitioner, appearing virtually on behalf of the petitioner submits, seeks for accommodation. According the matter be adjourned to the list the matter on.
Lordship, a small indulgence, Your Lordship could kindly record that nobody is appearing for the private respondent and the state respondent.
You are also not appearing. Why
Lordship,
you are appearing virtually?
Lordship,
Court is open and you are on the first half. Now you are appearing on second half virtually. This
Lordship,
indulgence cannot be given like that. No.
Lordship, Mr. Huda is leading me, Lordship, in this matter, but he's on legs.
So
in
you
some
must
other
appear. Mr. Huda is not there. I understand. Yes, you are appearing on behalf of. So you have filed one opposition.
opposition to the Milord writ petition as well as the supplementary affidavit. Copy served, Milord, upon the
Copies of they have submitted that you have served the copy.
on the same day upon.
One is for supplementary affidavit, one is for writ petition. Yes, Mr. Hudar is now here.
Is coming.
Why it is appearing under the heading to be mentioned?
It was as per your lordship's instruction.
Okay.
Lordship was directed to appear in the
Whether I have heard the matter?
Milord, matter Very heard, short Milord, point in for the for exchange of affidavits, Milord, matter fixed under the heading, Milord, to be mentioned. Now, Milord, copy already exchanged, Milord. Yes, we can reply.
When can it be
Actually, I would not want it to end appear under to be mentioned, but that's understandable. We have no issue, Milord.
Then if he has no issue, my lord,
no issue.
let it appear in the to be mentioned, my lord, as the matter has been appearing for quite some time now, my lord.
Then let's
They
take up
have-
the matter. We
yes.
have no issue.
They have, my lord, served us only yesterday, my lord. Lordship, my lord, keeps it any other day, any day as it commences to your lordship, any day. And in the meantime, my lord, if we file any reply, because they have also, though there was no my lord, direction, but they have also filed affidavit in opposition to the writ petition. So in case, my lord, we feel that we are required to file a reply to that, my lord, we will and serve them beforehand.
6th of May. 6th
6th
of
May.
May. Please take down. Affidavit in opposition.
6th
File on behalf of respondent number 6. To the writ petition is
Very
taken on
short point
record.
involved, my lord.
Affidavit in opposition on behalf of the respondent number 6 to the supplementary affidavit is also taken on record. Readings complete. Let the matter appear under the same heading on 6th of May 2000. Let the matter appears in the list on 6th
But the
of
matter
May.
will take some time, my lord, because various documents they have subsequently furnished, my lord. So,
Let hearing be start first.
Yes.
Lords,
6th of May 2025 under the same heading. Petitioner had leave to file a reply, if any, against the affidavit in opposition filed by the respondent number
24.
within the meantime. Next.
Oblige.
Grateful.
Lord, I appear on behalf of the petitioner. My lord. There is a typographical error, my lord. Last paragraph. In the order dated 16/4/20. The petitioner has last paragraph. In the first, the petitioner has challenged the selection of the private respondent on the grounds that the concerned authority has selected private respondent number 11. It will be 11 instead of
not 7.
Instead of 7, it will be 11.
That's all. Please take down. This matter appears for correction in the order dated 16 April 2025. At the last line of first page, the number of respondents should be read as 11 within inverted comma there are 11 instead of 7. Okay. In the same page, the representation
of the state is
representation by Miss Sonal Sinha and Miss Moon Ganguly should be on behalf of the state. Should be on behalf of the state. Next.
File an application for
What application?
addition of party and also file an application for vacating a booking order passed by your office. In this matter, vacancy was processed in terms of 2024 control.
Who is for the petitioners and other parties?
Mr. Agarwal, can you make it not today? taken up tomorrow.
In the same list, under the same heading. Tomorrow, Wednesday. Not today. Next. Dagun.
In this way, I apply for the petitioner, my lord. This is a contempt application, my lord.
Last occasion, my lord.
Last occasion, the petitioner was directed to serve a copy of the contempt petition upon the oil company, and that has been done.
My lord, I appear for the alleged contemptor.
Yes.
My lord, I say that this contempt application is not maintainable. My lord, let him argue. I'll take about 10 minutes on to argue the legal points. Factually, there is nothing to do. My lord, I say for reasons from the Contempt of Courts Act, this application will not be maintainable.
Yes,
Why I will certainly demonstrate, but let him place his case because it's his application. I have no issue.
My lord, before
But I don't think it
starting my
will come.
argument, my lord, well, one thing, my lord. The two annexure should be annexed to the petition that was not annexed due to inadvertently. One is copy of the review petition, another is an order passed by Lordship the Honorable Justice Joyce N. Gupta. Two documents is very essential, my lord. My lord, liberty be given to file a supplementary affidavit with the annex the documents, my lord.
Let them file it.
Let him file it. Let him serve a copy on my
Yes,
junior.
yes,
And let this matter be taken up anytime subject to your lordship's convenience. My lord, I'll take 10-15 minutes.
Yes,
And whatever time he takes, lordship can dispose
Yes,
it of.
yes.
Please take down. Petitioner, on the submission of the petitioner, leave is granted to the petitioner to file supplementary affidavit annexing certain documents. The copy of supplementary affidavit should be served upon the learned counsel for the alleged contemner earlier to the urgent date. Full stop. Let the matter appear in the list on 13th of May under the same heading.
Before that, I said,
Would it be 14th, my lord?
14th.
12th year.
Okay.
So for some reason.
14th Wednesday. Wednesday. No issue.
14th. And he should serve sometime before so that I can seek instruction. Grateful, my lord.
Yes. Next. My lord, I apply for the appellant.
I am for the petitioner in the contempt application. On the last occasion, as per direction of your lordships, Calcutta police station submitted report before your lordship. A copy was served. Today, they filed an affidavit in opposition to my contempt application. Today.
Where is the affidavit? My lord, this is my affidavit.
And I shall use affidavit in reply.
And my lord, I have also filed another one contempt application against the respondent.
It is revenge.
They have already violated the order, the same order. What is the application number? 612 of 2025. Is it appearing? Yes, my lord, it is appearing in the list. 612. Item number 31. My lord, number 31. Lordship, my lord, this is analogous matter, and my lord, two appeals are heard together, and my lord, the contempt also, two contempt petition. One filed by my learned friend, and I have filed another. Very good. My lord, in my opposition, I have stated my client has constructed one room taking the boundary wall. My lord, I have stated this should not be done without leave of the court.
Report is very
I tender my unqualified apology on behalf of my client also.
How many times your client shall
apology.
My client is present on his
unconditional apology. My lord, he is present in the
second time
court.
contempt.
He is aged about 80 years old, my lord.
Yeah,
No,
1950,
age is
2015.
not the bar. That I know, my lord. But
Understand
my
the
lord,
law or the direction of the
lordship,
law.
that should the order of the court should be satisfied, my lord.
No, this apology I shall take after hearing the matter. Okay.
My lord, both the contempt application will be
Not
hard
the
together.
first time contempt. This is second time contempt. Once court pardoned him.
And I know that fact. I know that fact.
My lord.
So this is the affidavit in opposition in respect of CPN 757 of
Lordship.
2024.
Lordship.
And what about your
Today I have received after a fortnight, fix a date after a fortnight.
after fortnight you want to file opposition against the 612?
In my application, they used
They filed the
opposition.
contempt application
Contempt
against you.
against me.
So you wanted to file any affidavit
In their
contempt application.
I will use opposition.
Okay.
And in their opposition, I will reply.
Affidavit in opposition on behalf of the alleged contemnor,
Named may be written, my lord, Anil Mondal.
namely Anil Mondal,
Anil
is taken on record. Petitioner within bracket Anjali Mondal is at leave to file reply against the affidavit. Full stop. The alleged contemnor, namely Anil Mondal, no, learned counsel appearing on behalf of the alleged contemnor within bracket Anil Mondal submits that the alleged contemnor has also filed one contempt application being CPN 612 of 2025. Present petitioner within bracket Anjali Mondal intends to file affidavit against the said contempt application. Let the affidavit be filed within 2 weeks. Be filed within 2 weeks.
Within 2 weeks.
From date. List the matter on the same heading on 20th of May.
I'm grateful, lordship.
Yes.
I have instructions to appear on behalf of the alleged contemnor.
34 and 35.
34 and 35. Milord, remembers these are matters, Milord, where we have filed these recalling applications on the last occasion on 11th.
Hearing has been done.
No. Milord, in connection to these matters, Milord, state has preferred recalling applications. My Lord will kindly remember on 11th April, your lordship dismissed the recalling application.
Yes.
Milord, 34, the recalling application, the dismissal order is there in the server. 35, the order is not there.
35 is not there.
The order is not available in the server.
I have signed both the orders.
Subject to Milord, my junior has checked even yesterday. It's not there.
Okay, I will deal with this matter. Okay, just time.
State will take up these matters
Okay.
to
No
appeal,
issue.
Milord.
No issue.
So 34,
very
35, let these matters appear after.
Let both the matter be urgent today.
Milord, may I pray for some more time? Because Milord, state will be carrying on these matters to appeal, Milord. May I come back before your lordship?
How much time is required?
Milord?
2 weeks.
3 weeks, Milord will kindly grant me. If your lordship desires 2 weeks, Milord, Milord will grant me 2 weeks.
Now I want to see where is the order.
My lord, may I,
In item number 35. 34 and 35, there are separate orders.
Separate orders. 35 is not available in the server, Milord.
Okay.
The 34th order is there with me, Milord. I can hand up you, Milord.
Let both the matter appear in the list on 14th of May.
I'm grateful, my lord.
2020 देखिए 34 টা দিন তো 34 টা দিন আর 34 35 টা দিন
Similar, exactly similar orders, my lord, but the numbers are different.
both are made server.
It is made server. It's not, my lord. My junior, there is some problem, my lord.
Both made server.
My lord, this officer will kindly check if we are opening the first one, the second one is opening up. The order of the other one is opening up. There's some difficulty with this
Okay,
server.
I'll check as the matter. দুটোই সার্ভার হয়ে গেছে
একবার দেখে নেবেন, একবার চেক করে নেবেন কাইন্ডলি।
হ্যাঁ কিভাবে করেছে দেখে নাও তো একটু।
14th May, my lord.
হ্যাঁ করে দিন। If it is not done properly, I will direct him to done again. Okay, no issue.
We are grateful, my lord.
Call the next matter. Ultimately, we can take new motion matter. দেখো $36 ডাকছেন না কেন? 36 ও 36 চলে গেছে, ঠিক আছে। ডাকুন 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 No one get interest. Forget it. Is there any matter?
55 I was appearing. So if nobody appears, will it be your lordship's pleasure to take it up next week?
Not next week. It will appear tomorrow again. If you want next week, I can pass the order. Let me call out the matter. At least up to 55.
হয়ে গেছে। Not today, not today. ডাকুন সাহেব বলছে ডাকুন।
Call it.
$55 I am appearing for the Union of India.
Which for the petitioner? Have you got instruction?
No. Actually, our principal grievances against respondent number 4 and 5, the jute authorities. We are only appearing for the respondent number 1, Union of India.
You are appearing on behalf of Union of India.
My lord.
So answering respondent is jute authority.
4 and 5. Allegation is against them, and prayer is also sought for against them.
Okay.
If my lord may takes it up next week.
If you want, I can fix it next week. Either it will be appear tomorrow again.
Monday, next Monday.
Not this week.
Great.
Call next matter. Mr. Sara, any matter is there?
58 private response. 58 private response.
58? Okay. Very well. Yes, Mr. Sara.
Item number 64, though mark is not this week, my other side is there. Madam. Then better kind take it up day after tomorrow as to be mentioned since my client.
Day after tomorrow, I have other determinations. Tomorrow it can be appear.
Tomorrow, no.
So it will be not this week.
Monday to be mentioned because my client don't want to push it.
Item number
64. Oh, mark not this week. My other side is there.
Monday.
Mark
Do you mention?
Old matter. 40টা কি হয়েছে not today?
হ্যাঁ